8th meeting of the Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since October 19th, 2021. Additionally, this month's agenda has been posted on the website since Friday, June 3rd, 2022. Now for the roll. Commissioner Begley.
Here.
Commissioner Diaz.
Here.
Commissioner Ferris.
Here.
Commissioner Franks.
Here.
Commissioner Gwynn.
Here.
Commissioner Moffitt.
Here.
Commissioner Smith. Here. Commissioner Torbett.
Here.
Chairman Grease.
Here. All right. It's in your opinion, Ms. Maxwell, we have a quorum, correct? Thank you very much. All right, next up, we're going to ask Commissioner Torbett to lead us in the invocation. And following that, if you will stand, she will lead us in the pledge to the flag. Ms. Torbett.
Okay, before the prayer, I would just like to say Commissioner Diaz had an accident on the way here yesterday, and he's fine. So I'm just thankful for that, and I will be saying that in my prayer. So when I say that, that's what happened. Bow your heads. Dear Heavenly Father, thank you so much for the opportunity to be here, and thank you for safe travels, especially for Jeff. Thank you for the protection that you gave him in his accident yesterday. Thank you for good health for all of us here today.
You've been muted.
I ask that you
To unmute yourself, press
decisions we
star
make today and
6.
bless our efforts.
You are not allowed to unmute. To raise your hand, press star 5.
In Jesus' name.
You are allowed to unmute. To unmute yourself, press star 6.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Stacy. At this point, we need to approve today's agenda. A couple of items I would like to note and ask the Commission to include on the agenda is a presentation from Rice Insurance, and I'd like for that to occur just after we approve the minutes. That's number one. Second of all, legal has given us a few additional cases to add to the consent agenda, and without objection, I hope you'll add those as well. Now, anybody else have anything they'd like to add or delete from today's agenda? If not, is there a motion to approve the agenda with those additions? Mr. Wynn makes a motion to approve. Mr. Diaz seconds the motion. Discussion. Those in favor of that motion vote aye.
Aye.
Those opposed, no. And that motion passes unanimously. Next up is to approve last month's minutes. You'll recall that meeting was in Memphis. And once again, I want to thank the West Tennessee commissioners for getting that set up, and it went without a hitch. It was a great meeting, other than the fact that a rock hit my windshield on the way back, Joe, and put a crack in it. But I don't think it was your fault. I just wanted to mention that happened. All right, is there a motion to approve last month's minutes?
So moved.
Mr. Diaz makes a motion. Ms. Smith seconds that motion. Discussion.
I wasn't here, so I won't.
Okay. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes on 8 aye, 1 abstention vote. Ms. Torbett abstains. Okay, next up we have Cindy Rice Grisham with Rice Insurance for a presentation. Cindy, if you'll use the podium, we appreciate you being here.
Thank you very much. I really want to thank the Commission and the Commission staff for allowing me to come and speak to everybody. It's always nice to get to see all the faces of our Commission and of our attendees in the group. And hello to everybody out there watching from afar. I'm Cindy Rice Grissom with Rice Insurance Services Center. We administer the Tennessee Real Estate Group Errors and Omissions Insurance Program. We have operated the E&O programs in mandated states for over 30 years. And we started writing the group program in Tennessee in 1991 when Tennessee started its mandatory insurance program. We currently provide the programs in 14 of the 15 states with mandatory insurance requirements that have group programs. We have partnered with Continental Casualty Company, which is a CNA company, to provide the Tennessee program since 2003. Our family recently sold the business of risk to Assured Partners NL LLC. We call them AP. The sale was completed on February 26th of 2021. All of our employees were hired by AP, and I continue to be the program manager for the Tennessee contract. We now operate in our office as a division of AP under the DBA Rice Insurance Services Center. Our office address and our phone numbers are the same. The insurance carrier is still Continental Casualty Company, and the current group policy is still exactly the same. So as a practical matter, our customers won't see much difference due to the ownership change. We are currently working with the state of Tennessee to renew the contract to provide the 2023 program with the same policy coverages at the same price, which is $230 per licensee for a 2-year policy term, which features $100,000 per claim with a $300,000 annual aggregate with a $1,000 deductible per claim for damages only. There is no deductible for the claims expenses and legal fees, which is a big feature for the program because most of the expenses that we pay out are actually for legal fees and other claims expenses. I want to talk a little bit about the number and of types of claims that we've seen. We actually handle the claims out of our office. We're located in Louisville, Kentucky, and our claims adjusters in our office actually are the people that you'll speak to if you have a claim. Most licensees think that a claim will never happen to them. However, over 24,000 real estate E&O claims have been submitted to risk since 2003, and over 4,400 of those claims were in Tennessee. This information is as of June 6th of this year. CNA has incurred more than $171 million for damages.
You are not allowed to unmute. To raise your hand, press star 5.
You are no longer muted.
They've incurred more than $171 million for damages and claims expenses on behalf of licensees that are insured through our program since 2003. Over $33 million of that has been paid on closed claims in Tennessee, and nearly $3.4 million is currently incurred for open claims. We reviewed the claim files to see the type of demand, the claimant type, the property type, and the deal type, and for claims that have been reported in Tennessee. In addition to the claims and the potential claims, insureds also can report regulatory complaints and subpoenas, as there may be limited coverage under the policy for those events. So we're going to look real quickly at the Tennessee E&O files and see what's been reported since 2003. I'm going to go by policy period and just let you know how many claims have been reported, just so you can kind of see each policy period, 2-year policy period. The 2013 policy period, there were 409 files that were reported. In 2015, there were 401. In 2017, we had 480 files opened. In 2019, there were 535 claims, and in the 21 policy, which is the current policy, we've had 339 so far. Of course, that goes through the end of the year, so there'll be more coming on. So it's been a total of 2,164 claims. Now, from those files, what type of demand do we normally see? 45% of the claims that get reported to us are actually litigation. There's been a lawsuit filed. 33% are non-legal, meaning there's been a written demand for money or services or a potential claim that's reported under the policy. 13% have been regulatory complaints only, and 3% have been subpoenas. 3% is a regulatory complaint that is accompanied with litigation, and 2% is a regulatory complaint that is accompanied with a non-legal written demand.
This is my bright idea.
Less than 1% are arbitration claims.
Oh, Liz, are you on here looking at this guy with the wild eyes?
Can there be an announcement to those people?
The guy with the wild eyes.
Okay, now we're going to talk a little bit about the claimant, the property type, and the deal type of the claims we've seen. 53% of the claims are bought by the buyer in a transaction. 15% are brought by the seller. 13% are not classified in our categories. 6% are lessors. Another 6% are lessees. 3%, the information wasn't available in the report. And then less than 1%, we've got government claims, insurance company claims, builder-developer claims, inspection company claims, the unit owner, the lender, or the title insurance company, and each of those was just a small number. As far as the property type, 70% of the claims are residential claims. 6% are vacant properties, 5% are commercial claims, 5% are property management, another 5% is not classified in our categories. 3% are condos and townhouses, 2% are apartments, and then 1% we have a number of categories, farm or agricultural, or REO claims, or mobile home claims, and then less than 1% we have multifamily residential buildings, other categories, business, and timeshare. As far as the deal type, the majority of the claims emanate from a sale. 55% involve a sale. 12% are involving a contract. 11% are property management. 6% are not classified. 4% are from a lease. 3% are from the listing agreement. 2% are from property showings. Another 2% are from construction and development contracts. And then the smaller numbers, we have auctions, we have agencies, we have offers, we have lease with an option to purchase, REO or sale of REO, we have appraisal, broker price opinion, and zoning as claims. So these examples help illustrate the types of claims that might be made against a real estate licensee. While a licensee doesn't have to do anything wrong to be involved in a claim, sound risk management techniques and good documentation can help to reduce the claims and reduce claim payments. The number one rule is always create a paper trail. If you've got it in your file, it makes it so much easier for us to prove that you didn't do anything wrong. Document your conversations, your recommendations, and your activities in a log. Confirm your conversations by sending a follow-up email. Keep copies of any information you provide to your client or others related to the property or the transaction. Keep organized, detailed records of all real estate transactions, including copies of all the signed documents. These practices might not keep you from being involved in a claim, but they will help reduce the time and the money involved in the defense and the resolution of the claim. I hope this information was helpful. I just wanted to give a brief update and also let everybody know that if they ever have any questions about the policy or the program or just anything in general that might relate to whether you should be reporting a claim or not, always contact us. You can go online. It's www.risceo.com. That stands for Rice Insurance Services Center, Errors and Omissions.com. Or you can call us on the phone, 800-637-7319. And it's a pleasure to be here, and if anybody has any questions, I'm available to answer them.
Commissioners? So, Cindy, I always find it interesting for you to tell us what's not covered. Maybe the top 3 or 4 things that are not covered?
Sure. The main things that we see when people report a claim to us and it's not covered, one of the biggest issues that we have is reporting. So when a claim is made against you, a claim is a demand for money or services in writing. So it could just be an email. So don't sit on it and wait until you get a lawsuit during the next policy period or, more than 90 days, because you have 90 days to report a claim. But if you wait longer than that, you might have prejudiced the claim and it might not be covered. We have reporting issues. We have sometimes if the owned property, if people don't have an endorsement for some of the owned properties. I'm going to pull the policy out here real quick and just tell the on the residential properties, the exclusion for owning the property is if it's a primary residence claim, it's automatically covered. So if you're selling your own home, that's going to be covered. But if it's property that you own that is not your primary residence, there's actually an endorsement you can purchase. It's called the Residential Personal Interest Coverage Endorsement, and that is $60 for the 2-year period, and that provides coverage if you're selling properties that you don't own. But it's really important to read the endorsement because there's certain requirements for that to apply, and I want people to know that. You have to have a home warranty, you have to have a home inspection, you have to have owned it for a certain number of days. So there's all that is set out in the specifics of the endorsement. All the endorsements are on our website, and I can send the information out to anybody that's interested. Other than that, those are really the primary issues that we see. The biggest thing that I think people don't understand is that it's a claims made and reported policy, which means it's not like your health insurance, it's not like your car insurance. The policy that applies is the policy that's in effect at the time the claim is made. So if you retire your license, you need to make sure you buy an extended reporting period, because if a claim is made after you've retired your license, you don't have a policy for that to apply to unless you bought the extended reporting period. And you can buy that for up to 5 years after your policy has expired. So the main issues that I see typically are involving people not understanding how a claims made policy works.
So just to follow up, and I'll go to Jeff. So if a real estate agent who has insurance with Rice decides to become a flipper of houses, buying them, fixing them up, and selling them, is there coverage on that transaction?
There can be. That's the endorsement that I was going to tell you, and I'll actually pull up the endorsement here real quick because it does have some specific requirements. You have to own it for at least 180 days. Which in this market is becoming harder to do because things are moving so quickly. It can't have been constructed or developed by the licensee. You have to use a board-approved state contract. The home warranty has to be, you have to have a home warranty, you have to have a seller disclosure form. If it's owned property, you have to let the other party know, so you have to disclose your ownership. There has to be an inspection, and those are the primary things. So that's really important. That's why I said there's a whole list on here of things you have to do for that to work. But it is good because it used to be that you couldn't get coverage for that. There's also a developed, constructed by spouse endorsement that's important to know about. So it also has some criteria in it. Let's see if I can pull that here real quick. So if you are representing a property where your spouse is the builder or developer, you have to have not been involved yourself. It's okay if your spouse is, but you can't have a financial interest really in the construction company, other than your marital interest, obviously. But again, some of those same similar requirements that were in the other exclusion endorsement we just talked about apply. And again, if you are interested in this, make sure you get a copy of it and you talk to somebody in our department to see, what do I need to do? What do I make sure that I follow?
Yes.
Hi, Cindy. When it comes up in terms of policy renewal, could you describe kind of the process you use to notify your clients that it's time to renew, and what tools and mechanisms they have to renew their policy?
Sure. We usually send a mailing out like in October, and then we send some, if we have your email address, we send reminders to remind people. But it's really important to make sure that people renew before their policy period. One of the biggest things we see with people not renewing on time is if it's a new licensee, and say they got their license in October and their policy ends January 1 of that following, they've only got a few months of coverage, and they think they paid for their full, their full next term, but they've only paid for a number of months. That's an issue we see. So make sure, like getting the word out to any new licensees that are at your firm, that when you pay your insurance, you got to make sure you paid the full 2-year term for the policy period, because some people just automatically assume it's an annual payment. But if anybody's late, if you find out that you were on vacation, you forgot to enroll, we can backdate people's policies. We automatically backdate if it's a renewal. If somebody joins in January, if they do the wrong date when they enroll, we automatically correct that before sending it to the Real Estate Commission. But if for some reason you put the wrong date in and your policy doesn't start January 1, you can notify us, and within the first 90 days, we can usually get that corrected. We just have to get a no claim. Like, you can't like not renew your insurance and then get sued and then come and ask for it. If you do that, they may be able to backdate it, but they'll probably exclude that particular claim. So things like that. But always remember, if you miss the date, make sure that you notify us or whoever you're insured with to make sure you have continuous coverage. Because the thing with the claims made and reported policy is you have coverage for your transactions prior to the policy period, all the way as long as you've been practicing real estate, as long as you've had continuous E&O coverage. So if you have a break in coverage, even if it's a one-day break, your retroactive date, which is the date that your insurance becomes effective for your prior acts, will be destroyed. So you want to make sure, always keep continuous coverage, always renew on time. If you don't, try to get it corrected as quickly as possible.
For those firms that have a group policy to cover all of their agents, there's times when they add or remove agents depending on when they release, et cetera. So how is that handled? Do you inform that firm that their policy's up for renewal, and do you have a roster of covered agents that you share with them?
Well, we don't sell firm policies other than the excess policy. So we have an excess policy that sits on top of the individual licensee's coverage. And for those people, we do check and make sure that their people are insured. We work with them to make sure. But if and this is something that people need to be aware of, if you move from an individual policy to a firm policy, your firm policy is only going to cover your acts while you're at that firm, because the named insured is going to be, Rice Real Estate. So if you worked at another firm before you joined Rice Real Estate, your prior actions that you worked when you worked at the other firm aren't going to be covered under your new firm policy. So in that situation, if you move from an individual policy to a firm policy, there's a way to fix that by buying the extended reporting, because you can buy the extended reporting on your individual policy. It will protect you. We had a terrible situation in one of our other states where it was one of our commissioners, and they had been insured with us forever, and they decided to move to a firm policy because it was less expensive. And they didn't tell me about it, and I didn't know, because we've got 120,000 licensees out there that are insured. I can't keep track of everybody, but I try. And they had recruited one of the top agents in the city, and there was $1 million claim against that licensee. That licensee did not have coverage for it because the new firm policy didn't cover their acts before they joined that firm, and they didn't buy an ERP. And it was really uncomfortable for me, because it was one of the commissioner's firms, and they worked at another commissioner's firm, and I was trying to make sure everybody understood and was happy. But it's an unfortunate situation. In that situation, the firm that he used to work for was covered, but that individual licensee didn't have coverage. So I think they worked it out where they shared some of the defense costs. I mean, they each had their own attorneys, and they both were represented, but it was not a pretty situation. So try to avoid that if anybody's switching. There's nothing wrong with switching to a different type of policy, but you just have to understand the repercussions of moving from an individual type coverage to a firm coverage.
Thank you.
Commissioner Smith.
Good morning. How often is we pay our insurance? Some of us pay it as soon as the bill comes. Wait for the light. Often it's that.
Make sure you're red. There you go.
There we go. How often do you turn in to the commission that insurance has been paid?
Oh, during renewal season, we're sending daily reports to the commission.
That was my question. Thank you.
Yeah. And I think probably during the year, I'm not 100% sure, but I know that it's at least weekly. It's probably daily too. I think in Tennessee, I think we send a daily report throughout the year. Yes, Caitlin has confirmed it with me. We do send it daily throughout the year.
And Cindy, you said that in October that you send out a notice. Does that notice go to the office or to the home address, or do you even have home addresses?
It goes to the address that we have that we receive from the Real Estate Commission. So whatever address that they have listed with the Real Estate Commission, that's where we send it. Unfortunately, we get a lot of return mail, and that's because people don't update their information timely with the Real Estate Commission. So if they haven't updated it with you all, then we don't have good data. Right. We do, if it's somebody that's a renewal and we get their return mail, we typically can, we send emails out to everybody. That's why that we have, if they're a current customer and we have their email address, we send it out. But then if someone changes their email address, then all of a sudden we really don't have a way to notify them.
So therefore, your email with the Real Estate Commission is so important, because every month we have people say, nobody told me my E&O was due. So, great.
Any other questions, comments? If not, Cindy, thanks for coming. I'm sorry to hear you sold your business, but I'm glad to know you're still associated with the company.
Thank you.
Yeah,
Thank you.
yeah.
It's all good.
That's all right. Great. Thank you. All right. Next up, we have 2 waiver requests. Just for the record, the people that are on the screen behind me, are they here for any type of this agenda?
We have tried to clear it up that you are not able to, at this time, receive education credit for virtual attendance.
Let's talk about that for a minute then. It's your sense that the people that are online hope to get continuing education credit for participating online?
Yes.
And do we have a position on that?
I think we would like to offer that in the future, but at this time, we're not currently meeting the virtual guidelines for an 8-hour course.
So the people that are tuned in may learn a bunch, but they won't get credit.
Correct.
Okay, just wanted to make sure that's what. But neither. We've got 2 waiver requests. They're not on the screen. All right, let's start with the first one then. Amber Pfeiffer, Caitlin.
Yes. So on your iPads, you should have information on a E&O waiver request for Amber Pfeiffer. Her license was suspended due to a lapse in E&O insurance, and then subsequently revoked for suspension for a year. And so on your iPad, you should have her license information, as well as she's waiving request for the retest and reapply.
All right, commissioners.
So,
Marcia,
I see the problem is pretty obvious to me. They have submitted certificates of liability insurance, which is different from E&O insurance. So if they think that their liability insurance covers the E&O, and that's not correct. That's 2 different types of insurance. So this person was thinking that they had insurance because their company had a liability insurance policy. So they've obviously been given notice. Their broker was given notice. They've let a year pass. And I think after a year has passed and they've been revoked, Anna, do we still have the ability to allow them to not retest for their license?
Yes. So after, even if a license has been revoked or a civil penalty has been sent to a principal broker, you still have the discretion to modify the discipline at that point, which is why the waiver request comes before you. I think the situation in this one, I know a little bit because I've spoken with the attorney that represents Miss Pfeiffer and and her principal broker, is that essentially they have a group kind of policy for the 2 individuals, and it just was not updated, and she was covered, but the information just was not with us at the time. So it's kind of one of those situations where we have the information. They did have insurance at the time, but we didn't have record of it.
Why did we not have record of it?
We didn't have record of it because of the format of how their insurance policy is formulated. So they do not have insurance through our specific carrier. And so if you remember before, when we when we came to the commission to ask for general guidance as it relates to like group policies, how those can be handled. This was kind of similar to that, but this happened essentially kind of before that guidance was provided. So that's the issue here. Is
So
that
you have that in hand, their policy for E&O insurance, not liability?
we do have the policy for insurance. We just didn't at the time have it because it wasn't in her individual name or the principal broker's individual name.
But specifically, it was errors and omissions insurance, not liability. Okay.
So just to follow up on that, she's asking not to have to retake the test.
Correct.
Did she pay $1,100?
Yes, she's willing to pay the amount of money.
Why would she be willing to do that if she had coverage?
And it's their the attorney, they're willing to admit that there was an error with the situation regarding not properly updating the commission, and so paying the amount that is fine. It's just the test is the issue here that they are not wanting to have to retake.
Yes, Jeff.
So it seems like to me, if we grant this waiver not to retest, she might be also entitled to a refund and a reactivating her license, because it seems like there was an error on the commission's part to suspend her license in the first place.
I don't think there was an error specifically on our part. The error was that they did not specifically give us the information that is supposed to be given to us. So they're recognizing that was a mistake.
And they have that duty to provide that to you.
Yes.
Okay.
And so they're paying the amount here. So she was covered. They're recognizing that it wasn't given the way that we have now stated that it needs to be individually delineated. But it's the test that she is asking for it to be waived.
So is there any sanction any sanction that could be imposed for not reporting or not updating the commission in the rules or the statute?
I don't think it would be necessarily a sanction for updating the commission. It would be that it's just like, remember the group policy issue.
So the $1,100 was a penalty.
It's a penalty fee.
So they're paying the penalty because they're acknowledging that they were the one that made the mistake.
Right.
And this person's been licensed for 12 years and has had no discipline history, correct?
So an $1,100 penalty for what amounts to a clerical snafu.
So how had the firm gone from like a traditional carrier to something different, and they just thought that, like, say Rice was sending information to the commission, but it wasn't being sent?
I'll say that the carrier that they have, I have not seen individuals have that type of carrier before. So I'm not really, but I'm also not very well versed on the land of insurance. So it is possible. But I do know that the coverage that is necessary was there. It is possible that there was a switch, but I don't have that specific information of why it was different this cycle as opposed to others.
Hey, Anna, thanks for your work on this. It says in the letter that Ms. Pfeiffer said that neither she nor her broker received corresponding letters from Trek regarding her license being suspended in January of 21. Is that when her license is suspended, does that trigger a letter from Trek?
It does.
Did they offer any ideas why they didn't get that letter? Or?
The letters are sent. That's often a statement that we get, that the letters are not received.
Right.
So that's like the unfortunate part, is that we send the letters. We can't guarantee that the letters are received.
Right.
But they had the address that we have on file at Trek. Was that their correct address?
Yes, that's a correct address.
Okay, and so the principal broker, has the principal broker been cited in this instance?
There is an open complaint against the principal broker.
And how many agents are affected by this? Are there other agents or just the two people?
Just these two.
So it's a company with just two people?
I'm not sure if there's just two people, but
Okay.
it's just this one agent. There are not multiple agents with the principal broker.
Okay.
Oh, Steve. Push your button, buddy. I've learned a lesson.
So when the this Transwestern, I think is who it is, says the certificate holder is Tennessee Real Estate Commission. So do they not send the certificate to the commission, and then what does the commission? What do y'all do with it when you get a policy that's coming out of left field? Do you say this is wrong, or do you just say, or what happens?
This has sort of been a long-standing issue because we don't know who to give insurance credit to unless it says whose policy it is, or unless the licensee is stated on the certificate of liability. So sometimes we get these certificates, but we don't know who to apply it to because it doesn't say which licensee. And the law requires that each individual licensee maintain, insurance. It does not have any requirement for the firm. And so it does create confusion. And sometimes we get these in the mail. So if an individual licensee sends it and lets us know that it is their policy or that they are covered under that policy, then we know to add it. But if they don't let us know, then we don't know who to apply it to.
Should we have some kind of policy or something that we say to the licensees, don't send us policies unless you have identified it, and don't assume that if you send something, it's going to get credited properly?
The commission did state, it's probably been at least 6 months now, that if you are going to do this, you need to let us know, and you need to let us know when coverage ends, because what also happens is maybe a licensee is covered under the group policy, well, then they transfer firms, so then they're no longer covered. And so the commission did state that there needs to be communication with the commission when you are covered and then when you're no longer covered under that policy.
And Ms. Pfeiffer's name is nowhere on this liability.
Right, I know, but so somebody's going to have to go to this form and call this Liz Malcolm and figure all this out, which is a lot of work for,
Is
our
this
staff.
Is this person from Chicago? Out of state? Because the firm is out of state. The insured is from Chicago.
According to her address on record, she's in state.
Hi,
And
Commissioners.
there are only three people, including Miss Pfeiffer. So 4 people, including Miss Pfeiffer and the principal broker.
Oh, just as a little bit of background, Caitlin, I'm asking you this question without telling you I was going to, but at the start of 2021, how many people failed to renew their insurance agent and are now suspended? It's in the hundreds, correct?
It might be a little bit more than that. I would say maybe closer to 1,000. But there's 40,000 agents in Tennessee, so and about 80% of licensees all expire at that time.
But what concerns me is any kind of precedent we might set by this. But what Anna has told us is that indeed this licensee was insured. She just failed to notify the state in a format that the state could recognize. I think that's what's in front of us. So, Commissioners, we need to make a decision to move on. DJ, you want to talk to it or make a motion?
I move to waive the retest and accept the penalty of $1,100 that she's already paid.
Got a second by John Moffitt. Discussion on the motion, which is to allow this licensee to regain active status without taking the test. Any discussion?
Can I ask this?
Sure.
How will this affect the case that we have against the principal broker?
Well, we can, let's
One problem at a time.
let's bring it up after we vote on this motion. And let's see.
Okay.
We'll handle it then. The motion is to allow the licensee to get back in business without taking the test and be satisfied with $1,100 civil penalty. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no, and that motion passes unanimously. Now, Ms. Franks, about the principal broker. What are your thoughts?
So I'm thinking if I'm the principal broker and we just found the agent, not guilty.
That's not the right way to.
Not the word. Not guilty. Not in violation.
That's
the right
closer.
word.
I like it
Is that
better.
They did pay the fine.
The principal broker did?
No,
The agent.
Oh, yeah.
she did pay the
They were
penalty
not
fee.
guilty. We just said we were waiting.
As she said, she didn't get the letter, but she's paid that fine, so she's perhaps acknowledging.
The penalty fee is still remaining. We're not
Okay.
refunding.
We probably need to wait until that comes before us to.
So
Talk about it
at this point, I'll leave that up to you whether you want to move forward on it.
So if there was insurance, and there was, I mean, we've just decided there was insurance, then if we can, I'm not sure what we have to discuss about the principal broker.
Yeah, I think we wait until it comes before us.
It won't necessarily come before you
Okay.
because the law allows for them to have. Typically, what happens is an agent lapses in their insurance. We offer this settlement offer to the principal broker by the set determined amount that's in the law, which is $200 or $400, and then it's a set amount once it gets to a year.
Oh, and they
Don't
and
need to
against the
discuss
principal
it then.
broker, the complaint.
Open.
It's still open, but it would be a failure to supervise. All right, so
Okay.
so if there's insurance, then there's no failure to supervise.
Well, there was a failure to appropriately inform the commission, correct? I would entertain a motion or discussion about giving some type of penalty, maybe perhaps not 1,100 to the broker, but
I think we have to let it play out.
okay.
I don't think we don't have any information before us today other than what we had on the other person. I think legally we probably need to just move on, and if it comes before us, we'll handle it then. If not,
What do you think, Anna?
So the complaint as it is right now remains open, is a violation for failure to supervise, for failing to ensure that the licensee has continuous errors and omissions insurance.
we don't have a response from that principal broker yet.
Well, I've been in contact with their attorney, and the first thing that we wanted to deal with first was the affiliate broker before the principal broker. But we've already kind of made the determination here that the matter related to insurance doesn't really apply, as there was continuous insurance. But
We've never skipped this step though before. I think we have to let it play out.
So whose job is it to inform the commission? The broker or the affiliate?
principal broker's responsibility.
It wasn't the affiliate's responsibility to inform the commission. It was just the brokers.
I mean, I still think it's a principal broker's responsibility to inform the commission regarding the insurance matter. I just don't know if the appropriate violation would be for failure related to errors and omissions insurance. It might be related. I think it might be more so related to failure to update the commission related to administrative matters, informing the commission related to that.
We're not even certain what the complaint's going to contain at this point.
But at this point, I'm not prepared to make any of those decisions at this point.
Okay, I think Ms. Frank's advice is appropriate. When it shows up, we'll handle it. Yep. Okay, next up we have one more waiver request. Amira Hamuya, I'm thinking that's how you say it. Caitlin, will you give us a little background on this?
Yes, I will. This is a fee waiver request. This is the true medical waiver request. And the waiver is for the reinstatement penalty. This licensee expired June 11th of 2021. And they have provided a letter to the commission, as well as some supplemental doctor's notes.
Motion to approve this request.
Second.
Motion by Mr. Diaz, seconded by Mr. Nguyen, that the licensee's request be granted. Discussion. For the record, to the people in the audience, this licensee provided extensive documentation that I think caused these two commissioners to make a quick motion. Any other discussion? If not, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no, and that motion passes unanimously. Next up, E. Ross White, Education Director, Tennessee Real Estate Commission, proud grandfather.
Thank you, Mr. Chairman, members of the commission. Good morning and happy beginning of the summer to you. I call your attention today to the Real Estate Commission Education Agenda for June 8th, 2022. I have reviewed all of the courses, the instructors, and the providers on today's agenda, and I believe they comport with the law and the rules, and I present them today for your approval. That would be J1 through J25.
All right. Is there a motion to accept council, the education director's?
I'd like to pull one.
Okay, we'll get you. I got a motion to approve by Ms. Torbett, seconded by Mr. Ferris. Now, does any commissioner like to take one or more of those courses out of this motion? Ms. Franks.
I'd like to pull J10 for discussion.
J10 is out of the motion. Anybody else? If not, let's vote on the motion, which is to approve courses J1 through J25 with the exception of J10. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. Now, Ms. Franks, you have the floor.
So J10 was interesting to me. It's called Building Stronger Communities Through Metro Schools. This is a class from the Greater Nashville Association of Realtors. It says the unique course will allow realtors to learn the various models, funding sources, programming, and academic improvement areas to better serve their clients in Greater Nashville area. So, it's going to be taught by Dr. Adrian Battle, who is the Director of Schools for Metro Schools. So my question, Mr. White, is this a class that's only going to be taught in, I'm a little bit confused because I'm from Williamson County. We have two different school systems. Is this something that's only going to be taught in Nashville? Is it open statewide? There's like different models of in schools and everything statewide. So I was wondering about that.
All circuits are busy now. Will you please try your call again?
Sorry.
Thank you, Commissioner. This course is rather unique. It's a 1-hour course. It's being promoted by Greater Nashville Association of Realtors. So just to be clear that any of our courses and providers' courses should be open to all licensees. However, certainly this one is targeted through Dr. Battle's office to the Greater Nashville area. And I would assume that takes in all of Davidson County and maybe the surrounding counties as well, as far as anybody that would wish to attend it, because they may have children, interested in those schools. However, it is a unique course, as we say here. Dr. Battle has an illustrious background and career, as you can see on her background for instructor. So I saw that this was a very interesting course and would be interesting for all licensees, certainly in this area, as they're dealing with their clients and the children of those clients and so forth.
So this is not a course about just for instance about charter schools versus regular schools, or I know in Davidson County that they have some specific schools for the arts and things like that. What do you call those schools?
STEM academies.
No, they don't call them that.
You asked me what I call them.
Yeah. Okay. So I guess here's what I'm getting at, Ross. As realtors, we have to be as licensees, we have to be very, very careful not to steer according to schools. And I always tell my agents, give them the place where they can go for the information that shows the grades of the schools and things like that. I'm just wanting to make sure that this is not a political course of any type.
From the background that I read, it has no political part at all.
Okay.
It's rather just for all interested in what Dr. Battle's office and what she supervises, essentially the Metro school system. So I'm assuming that's mostly public.
And so she understands that she would be the instructor, not someone from her office?
Absolutely. She is the instructor, and she hand-signed and
perfect.
Notified us about that. So
then
let me get one more, Commissioner. Commissioner Diaz.
Mr. White, in your review of the course, did you review the course and what she submitted?
The documents that were submitted to me, yes, sir.
So, but you haven't seen the materials for the 1 hour?
I saw the timed outline and I saw the background that was submitted, and it's fairly very designed well, and so I saw that it was proper for presenting today.
See any indication that she has, I guess, reminders to the students in that class about their obligations under federal law regarding steering and fair housing?
I'm sorry, I did not see that within that. I think this is rather a larger encompassing view of what Metro schools offer, and then for the idea that one of our licensees, certainly through Greater Nashville Association of Realtors, their membership, but it has to be outside of their membership, for all to see that it's for their information generally.
I may offer a couple of remarks here, and thank you for looking at this, Ross, and vetting it, and perhaps there needs to be more vetting, but it sounds good so far to me. As a licensee with GNR, there is a history with GNR. I think there's an actual committee currently, it's Public Education Committee, where there's a lot of effort from GNR to have licensees sponsor a school, if you will, volunteer on the grounds, volunteer with teacher lunches and things to just, in other words, build strong communities. So it strikes me as just a additional way to educate licensees, and if we could emphasize that there is no steering or no, you've got to go to Metro schools if you're going to sell a house in Nashville, the obvious. If we could emphasize that, I think it ought to be good to go.
It's completely generic, Commissioner, in that regard. It's just open for all.
I'm supposing, too, with it being a 1 hour course, it could be something that they're adding because she would be a huge speaker to speak before anyone. That maybe at one of their big meetings or something that she's going to be one of the people that speaks or something. So that's why I think maybe I don't see her wanting to go statewide with this.
Oh, no. This is.
So I would make my motion to approve J10.
Mr. Ferris seconds that motion. Discussion. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no, and that motion passes unanimously. All right, Ross. Now the instructors.
Thank you, Mr. Chairman. I present to you the 4 instructors and their backgrounds today for your approval.
Move to approve.
Second.
Motion by Ms. Frank, seconded by Mr. Diaz, that the Education Director's recommendation be adopted and 4 instructors be approved. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. Anything else for us?
That's all I have, Mr. Chairman.
Thank you. Thank you for what you do.
Thank you.
Caitlin, let's do your executive report, and then we'll take a break.
Hey, sounds good. I just have a few updates for the commission. One is with CE Broker, which I have mentioned a few months back, but we are currently doing provider training for CE Broker. There's one this afternoon, and there was one last week. And so CE Broker is going to provide our education providers with additional options to add CE course credit. And so within the next month, we will be moving over to the CE Broker system. I think there will be, most people don't like change, so I do expect a couple months of working through the kinks of the new program. But that will be happening. I'll likely have an update for the commission at the July meeting. Because we report and licensees take education all the time and their status changes all the time, we're going to have about a 2-week period where rosters will begin going to CE Broker and stop coming to the commission, and we'll also be sending CE Broker the updated license statuses and updated education from the last time we sent it over. So there's a little bit of a 2-week down period where we also will be having licensees. We've worked with legal, and they will be attesting to their education. And then during that 2-week period, we will be auditing all of their CE. There's really no other way for us to do it because we're not a board that renews at one time, or people take education, their record is constantly changing. So I will have a further update at the July meeting for everybody, but just wanted to keep the commission in the loop on that project. And then on the, yes.
So could you just, and especially since we have so many in the audience, can you just give a little synopsis of what the CE Broker is?
Okay. So we found CE Broker when I first started with the commission, because right now education providers send in their roster, and then we have to send it to our IT department, and then they upload it. And we were having a lot of issues if the record wasn't exactly correct. There was delays for the licensee, if maybe the first name was wrong or the license number. And so CE Broker is, I'm going to call it a platform that allows our providers to log into their account, upload their roster, and in real time know whether there's errors. And so the goal is for it to streamline the education process and remove some of those issues that we have had in the past where they will immediately know if they have the wrong license number or the wrong name. And then if they have a small class, they can manually add each person and immediately add it to their record. And then I think it's going to allow for, on the licensee side, additional communications where we can remind licensees more about their upcoming renewal, or if they're lacking CE, there'll be additional communication options. And then also, we have a lot of nuances. The 120 hours has to be done in 3 years, which is in the middle of a renewal cycle. We have people that are grandfathered. A lot of those things, CE Broker is going to be better equipped to handle.
So this is a huge benefit for our licensees.
Yes. I do think
if there is a change.
It is a change, and so I know when we switched to core, it took a couple months for everybody to get on board, and I do expect the same. But I think in the long run, it's going to be a benefit to everybody.
Thank you.
All right. Before we break, I have a couple introductions. Former Commissioner Diane Hills is here in the front row, along with her bodyguard, Bob. Diane was a great member of this commission, and she still has an interest in what goes on to protect the consumers in the state. And we appreciate you being here, Diane. Bob, it's good to see you as well. I'm not sure which one of you has the pistol, but I know there's one somewhere close by. I'd also like to introduce, the Department of Commerce and Insurance is the umbrella that has dozens of divisions, and the Tennessee Real Estate Commission is one of those divisions. Carter Lawrence is the big dog at the Department of Commerce and Insurance. I've tried for years to get him to shave because I think he would look better, but he thinks it makes him look more mature, I believe. I'm not sure what it is. But I'm going to let Carter talk if he wants to, but I'll tell you one of the great things that happened. Carter and I were on the search committee trying to find a new executive director at one point. And fortunately, the committee chose Caitlin Maxwell, who's a star. It was the best decision I've been involved in. I can also tell you the worst, but I won't. So, Carter, come up and say hello.
Not you.
And Carter is the Commissioner of Commerce and Insurance.
He's the big dog.
Yeah, well, thank you so much. Appreciate the introduction. Alex Martin, the Assistant Commissioner for the Regulatory Board Division at Commerce Insurance, had texted, John, it had slipped my mind today being your last day, so I wanted to come down and say, or your last board meeting to chair.
On my last day, thank you.
Yeah, I apologize. But I wanted to come down and personally say thank you. So John mentioned us working very closely with that search committee. At that time, I was the assistant commissioner for the regulatory boards, and I had the pleasure to work very closely with John, along with several other folks still on here. Marsha, it's great to see you. And I've always been really impressed, John, with your professionalism, your leadership, and your taking of the really big responsibility of being one of the regulatory entities for such an important by the commissioners. And I just wanted to come down and say thank you so much for your service to the state of Tennessee and to your profession.
Oh, thank you, Carter. Let me say this. There are 47,000 plus active licenses in the state of Tennessee managed by this lady and her small skeleton staff. And you all, I know, are aware of it, but I can't, every month I want to make a point of how smoothly this department is running compared to years past. And it may make us look good, but we don't get the calls we used to get because it's handled. She does a great job, and her staff does. Legal, Anna has provided great advice to us over the years, and if only I could see Mark Green right now and tell him to shave too, I'd be really happy.
John, you and my wife are always trying to get me to shave, but and I'm still one of the younger commissioners and need to at least fake a little bit more maturity than I might otherwise show.
Thank you, Carter. We appreciate you coming. Alex, thanks for coming down as well. All right.
Toby as well. We can't forget
Toby,
about our fabulous deputy commissioner.
Bonnaroo is coming up soon, right, Toby? All right. Unless anybody wants to keep meeting, we're going to take about a 10-minute break, and we'll be back to finish this up. Thanks.
Thank you. That's very nice.
I looked. I was like, if I go get my coffee, can anybody see my feet? I thought maybe they can.
Congratulations, man. You did a great job. Well, congratulations. I just think you did a good job.
To shave.
Mark's going to be done. Oh,
Yeah.
good. I look forward to telling. I'd like to let the audience know that I have some good news and bad news for you. We have 65 cases to consider today. The good news is that this commission, a few years ago, adopted a consent calendar. And so all those cases, with a few exceptions, have been reviewed by us before this meeting today. And so there are some cases that each case has a recommendation from legal on what we should do with it. we can accept council's recommendation. We can discuss it with council. We can change council's recommendation because their recommendation is not as important as what we want to do with it. It's kind of true.
He's a lame duck.
Yeah. So we have some cases pulled out. So out of the 65 cases, for those of you who'd like to make notes, these are the cases we're going to discuss. These by case number 7, number 10, 14 and 15, 22 and 23, 25, 33, 35, and 37. For your information, case 45 has been taken off the agenda, and number 46. And then we'll also discuss cases 50 through 62 and 63 through 65. Now, commissioners, have any other cases you want to take off?
Please, no.
Any other cases to take off? If not, is there a motion to accept council's recommendation on the balance of the cases with the exception of those that I just listed?
So moved.
Ms. Franks makes a motion. Mr. Diaz seconds that motion. Discussion on the motion. If not, let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes and those cases are handled. In the past, we had to read every one of these cases in individually, read the case, the narrative that council writes up for us, and it took hours. I will tell you one more thing before we get started. Our two attorneys up here get the cases, they get the respondents' comments, they create a narrative that is so generic that we have no idea whether we're talking about a male or a female agent, whether we're talking about East Tennessee, West Tennessee, whether we're talking about Cry-like or RE/MAX office. We have no idea. All we do, and what they do a brilliant job of, is giving us the facts and giving us their recommendation and then letting us discuss it if we choose to. And we're going to do that on a few cases, starting with number 7. Dennis, Jeff Diaz pulled this case.
Yeah, with that as a theme to mine, the cases that I pulled are more just from my education more than any dispute with the narrative. But on this case, this is the issue where there seems to be a thought that there were some repairs that were promised, but that weren't completed. And I just wanted to see, is there anything in the record that would even look like a repair or a resolution agreement that's been signed by all parties?
Well, let me take a look and see what is a punch list signed by.
Is it signed by the seller or the builder or anybody?
Punch list sounds like a builder document more to me than a. Is the seller the builder? Is that in the narrative? No.
Yes, I believe you're. That's the only thing that the complainant didn't provide anything more than just a complaint or standard complaint form, and then the lion's share of any documents were all provided by.
Comes down to more of a contractual dispute then between a buyer and a builder.
Couch it as, yeah.
Okay.
Was there a final walkthrough sheet?
One done, of course, under. other than the punch list.
We have no signed agreements between the two parties.
The only thing that's contained is a builder's orientation sheet, which is prepared by or done by the builder itself. Builders items.
Motion to accept council's recommendation.
Second.
Motion by Mr. Diaz, second by Ms. Franks, that council's recommendation be adopted. Discussion. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. We didn't pull number 8, but I'll just note in number 8 there's a line that says, the respondent says the complainant told him that his brother may have cooked meth in the house while he was in prison. Now, who was in prison? The guy cooking the meth or his brother?
It was, they both apparently spent a little time, maybe one more so than the other. But
I just would like for the audience to know that council has to deal with all kinds of situations before they make their recommendation, and that was one that caught my attention. All right, we'll move on to number 10. Jeff?
Okay, so this is a question about Fair Housing Council. It came up in a recent meeting with NAR about licensing boards and the Fair Housing Act. And my instinct tells me that this board doesn't adjudicate Fair Housing Act claims. That's done by somebody else. But is there, subsequent to that kind of adjudication, if a licensee is found guilty, is there anything that this board can do in addition to that if we're informed of a guilty verdict or a plea guilty?
As long as it involved a real estate transaction as we define it, I don't see why not. Coming to us in some other means, a couple different ways.
So is there a line of communication that exists where we would be informed of such a thing, or is that just kind of if we happen upon it?
Well, that or like in if this particular complaint, obviously the complainant talks about, Human Rights Commission. There are ways to find out whether or not the complaint was lodged, and because we don't know whether or not this complaint is going to actually do what they say they're going to do here. This person says that they have, but there could be a means of finding out, from one agency to another, whether or not that there was a complaint and what the outcome was. That could.
Motion to accept council's recommendation.
Got a motion by Mr. Diaz, second by Ms. Torbett. The council's in favor of that motion, vote aye.
Aye.
Those opposed, no. And the motion passes unanimously.
This is a process thing. I'm just going through all kinds of education for myself here, and I guess maybe some other commissioners. So you talk about an investigation being launched. Is that something that's going to be sourced in the Real Estate Commission, EG thing, or Attorney General?
That would be for this particular. That's why I put it on for discussion. Is to kind of get a take on this based on the complainant's information.
Hey, Dennis, and give us as much background as you want, because your recommendation is to discuss. So there's something about this you're unsure of.
In the complainant's narrative, essentially they say that every employee, this is quoting, every employee in every market is aware that the respondent has been assigning applicants and prospects outside of their jurisdiction. Well, there's no way that we're going to really know any of that. An investigator from this agency, that's how we would approach it, not to rule out the Attorney General's office for matters like this, but I think just initially we would assign this to, it might have disgruntled, I think you can agree, disgruntled former employees' complaint. So, try to get a less biased view on this complaint. We would have to send someone out with a list of questions that I would come up with most likely and have them ask them. So
that investigation obviously would need time to be done.
Sure. Days. That's normally what we've been doing.
We defer this case until such time as staff can complete an investigation and make a further recommendation.
Second.
Okay, the motion is much time as necessary for staff, including an investigator, to report back to commission. Question on that? What if the investigator finds what the complainant would it be that he's paying people who don't have a real estate license, or she, or?
Well, I think it would just be a matter of unlicensed activity. I mean, if these folks are actually in a transaction, keep kind of going back, it's defined throughout the statute, then it would just be unlicensed activity, I think. But the individuals be engaged in unlicensed activity, but whoever, in this case, it'd be whoever, I guess it would be the firm, because that's what the license, as opposed to, an affiliate or a principal. But then it moved to discipline the firm as well.
Thank you. Motion on the floor. You've heard further investigated. It's Jeff. Jeff, back to you on 22. 15 first.
So this is the case where the complainant is alleging that the seller of apartment complexes or a fourplex leases and did not transfer them to the new owner, thinking that the new owner was going to renegotiate the leases anyway, so there was no point in maintaining the record. In my case, the green book, or the red book, depending on which one you have, and I did not see any specific the transfer of existing leases to a new owner. So, do you know of any requirement?
I'm not aware. The only thing that I cited was the in Chapter 13, 312.6. There is part of that talks about holding on to essentially
retention
documents for up to 3 years. Well, even in this case, the documents, the leases were 3 years and older, so presumably she held on to them up to, we believe they may have been, as far as a rule saying, thou shalt transfer all leases. No, I don't find it. And I went back and looked at the purchase and sale agreement, and there was nothing in the notes about that they had agreed that would happen. There was talk about the repairs and whatnot, because that was part of the complaint as well. Was I think they were kind of disputing about whether or not there was one window that was in there.
Was that a residential purchase and sale, or was that a commercial purchase?
It was a residential.
So, I also pulled this case, and to me, it looks to me like we've got a property manager who's about to lose her job because the new owners come in, and he or she, the property manager, says, let's just throw these leases away and let them get started on their own, which to me is not even close to right.
Right.
That's how I see it right now. Is there anything wrong with how I see it, Dennis?
Well, no.
You can't document it.
Right. But I mean, it could go back to just like a lot of these dudes are just reasonable skill and care. I mean,
yes.
She was the owner and property manager and a listing agent, and while she did provide a list of I think there were 4 tenants, provided the names and the amounts that each were paying, the leases were not provided, and again, we think maybe they were just shredded.
So the respondent to this is a licensee.
Yes.
Okay.
Yeah.
And did they hand over the deposits to the new company, or was that even mentioned? That's usually where the problem comes, is getting those deposits.
That didn't appear to be a problem.
Okay.
No.
Go ahead, DJ.
I hear your concern, and I could share some of that about as colleagues, as professionalism, courtesy. That could have occurred. They did say that provided all the names of the tenants, and this is a key point, their respective rent amounts. And I'm recalling a time where my wife and I purchased a duplex from a gentleman and his wife. One side was rented, and I think he sent me over the lease that he used, but at that time I had leases of my own that I preferred, and the most important information that he provided for me was the name of the tenant, which I actually knew through him, their contact information, and what was being charged. So I used my own lease so it really, I think, from my stance, I think the respondent could she have offered more? Yes, but I don't think she was negligent necessarily, unless I'm told otherwise.
Dennis, has the respondent responded to you at all?
Other than just providing the response to the complaint, the complaint goes out, respondent gets the allotted time to respond, and that's the only response we've got. No, I've gotten no other individual contact from this respondent.
I mean, it says that all tenants had been in the units over 3 years since signing their initial leases. There's not a lot of residential leases that are signed over a 12-month period. So, I mean, she may just assume these aren't really valid. They're month to month at this point. And unless you're annually renewing those leases, it goes month to month. Were they even valid leases is my question. Were they even a lease at that point?
In the written leases there's some kind of,
I wrote a lease 3 years ago. In
Right.
that lease, it says basically you go month to month after the 12-month period, unless you renew on a new lease. So was there a valid lease intact with these people to even discuss?
With
They were
renewal
destroyed,
language.
but the leases were destroyed, so we don't know.
But the problem is,
Verbal
it
issue.
comes down to courtesy and law. So
Right. I mean, there's
no
a
law that we
statute-
got to be courteous and we got to do these things. And I'm with you that they should have done better. I'm just not sure that maybe this is something that could be an ethical complaint to their board.
So I want to follow up with something else on it. So Dennis, you said that the listing agent was also the owner. I didn't see that in here.
Let me make sure
Listing
that
agent
may have
and
been
property
just something
manager.
that I knew that I didn't include in the summary, but hold on, I can tell you. Here it is.
As the respondent is the listing agent and property manager in the narrative.
All the tenants stay? I
Right,
mean, was there
so-
any harm whatsoever if all the tenants stayed?
So the owner is an entity.
The construction company.
Right.
All right, so
not the respondent is I'll correct myself, the respondent's not also the owner, just the listing agent and the property manager.
So I see this a lot, and it's not legal by any means, but there are real estate companies out there who let their agents freelance as property managers. So the agent collects a fee from the owner for leasing the space, for monthly maintenance, supervision. They get paid not through their broker, but from the owner directly, which is a clear violation of anything that they're supposed to do. Why wouldn't this affiliate broker's company or principal broker be the subject of the complaint unless this agent is just freelancing on his or her own? Just talking out loud.
And it was opened against the real estate firm, not a person or not an affiliate, a broker, or a principal broker.
Well, it says it's opened up against the affiliate broker.
It's the affiliate broker. It was opened up against the individual affiliate. Right.
The affiliate, we're not sure if the affiliate owned the fourplex, or was that just established?
There is a construction company that owns it, so it's not owned by the affiliate.
And do we know if the affiliate has ownership in the construction company?
Well, the affiliate's spouse, I believe, does.
Okay.
Here we go.
So, Jeff?
I guess I opened this can of worms. I guess it's only fair.
recommendation is
their property.
close.
Oh, I'll make a motion. See how we do. Motion to accept council's recommendation.
Okay, I've got a motion by Mr. Diaz, seconded by Mr. Gwynn, that council's recommendation be adopted and this complaint be dismissed. Discussion. Steve?
Complainant held all the cards. He or she had the money to buy the building. If she wanted the leases, don't close. It's very simple.
Put it in the contract.
This is after the fact. She controlled everything, or he. So if she wanted the leases, put it in the contract. Make sure they're there in your possession, or don't close. It's very easy.
I got it. Any other discussion? The motion is to accept council's recommendation. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. Chair votes no. That motion passes on 8 aye, 1 no vote. Next up, number 22.
Hopefully this won't be quicker. I just want to change the recommendation from a $500 penalty to a $1,000 penalty. I make that motion.
I also pulled that one in for that very reason. This was a TikTok ad. We're getting into new waters here now with different kinds of advertising.
I was thinking the same thing. There's probably nothing in this book about TikTok.
No, there's not.
Well, there might be. We talk about social media.
Social media.
But you could
But
put this
still,
in.
I feel like TikTok is a whole different animal.
I don't know much about TikTok myself, but
That's what you can do when you retire. You can become
when
TikTok.
on my last day, I can go to TikTok.
This is for cases 22. Mr. Chairman.
Yes,
This is
sir.
for cases for 22 and 23.
Yeah, same thing, just two different people did it.
And I make the motion to increase the penalty to $1,000.
Okay, we're combining two motions, case 22 and 23, and the amendment to council's recommendation is to increase the civil penalty from $500 to $1,000 on each of these two cases. Everybody clear on that? And that's the motion that's on the floor. Jeff made it. I'm unclear about the second. Stacy made the second. Seconded. Okay, discussion.
This is so that we can be consistent with advertising violations that we usually do a $1,000 penalty for advertising violations.
Well, the first time it's usually $500.
Well, we don't know if it's the first time.
I'm just saying we're not being necessarily consistent or inconsistent. We don't know in this case. But the commission can always override anything we have done in the past, and we're about to, perhaps. All right, any other discussion? Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no, and that motion passes unanimously. 25. Jeff?
It's me again? Okay. So, Dennis, do we have any idea who held the earnest money? Is that the licensed broker or closing attorney or title attorney?
Well, this was just the principal broker's sort of narrative that he provided us with, but let me go back and look at the original.
There's a lot of applesauce in here.
It kind of looks like the principal broker is putting it off on their compliance team.
Whoever that is.
Yeah.
They are responsible for regardless.
No, to answer to your question, Jeff, I don't think there's any
We don't know who held the earnest money. It was just absent.
It was just absent.
Okay.
They have a system, a computerized system that's supposed to handle all of that.
The record doesn't tell us how that earnest money was dispersed. Is there any?
Jeff, what are you trying to accomplish?
Well, I'm just trying to see who had the money and whether that money was handled properly. And the narrative to me didn't.
They had the money, did they, Dennis? Didn't they contact the law firm to ask for the money or see if they had the money and never got a response?
Right.
Yeah, so apparently they were supposed to, the earnest money was supposed to go to a law firm, but they were just checking to see if it was there. And they failed to receive a response.
And there were wiring instruction mishaps. And no communication.
So it just seems like this deal became a big mess. But there's nothing to find a violation on.
And this is from the part of the respondent's response. Prior to the October 28th, 2021 date, blank never received any notice from either the seller's agent or buyer's agent that the earnest money had not been received. As far as this would have been his broker, as far as his broker knew the transaction was proceeding, and all parties on the buyer's end were diligently working toward a closing date of October 29th.
I personally think there has been a violation for sure because, in good faith, the listing agent, at some point, when they received a request to extend the closing by 2 weeks, they signed an extension with an agreement that the earnest money, that the buyers would relinquish their earnest money if closing did not occur on 10/29. Well, it would be at least a duty of that agent to know that they had received an earnest money check. They have to know before you promise somebody you're going to relinquish that money and you don't even know if you have the money. I think there's definitely a violation at that point.
Whether it's wired or handed to you in a check or whatever.
You're promising somebody they're going to get an earnest money. If this doesn't work out, you need to know that you've got the earnest money.
Received.
Jeff. DJ. I got Jeff. Since you still have the floor, if you'd like it. Wait a minute, DJ. You had your chance. And
Snooze, you lose.
All right. I'll tell you what.
Go ahead, Jeff.
I'll just do it again. We'll make a motion to accept council's recommendation.
To close it?
Yeah. See if,
Okay, I have a motion by Mr. Diaz, seconded by Ms. Torbett. Council's recommendation be adopted. Now, DJ, discussion.
To your point, Joe, the complainant is representing the seller. The complainant is the one who needs to make sure the earnest money is in hand. They're complaining. I mean, and plus, and this is again something to be clear for the audience. This complaint is from the listing agent against the buyer agent's broker. So the consumer's not involved here in this complaint. On one hand, the consumer's always involved. That's who we're serving. It did become a snafu. Jeff, I agree with you. There was a moment in here where the principal broker says, "Contact my client." It's like,
who does that?
That's just,
it's ethical in violation.
So it makes me. I'm not saying this is this case. It makes me think about our clients and our friends and our people that are in our community who think, you don't need a broker, you don't need a realtor, you could use a discount service, and you can choose to do that. And you get what you pay for sometimes. I'm not saying that this is this case because we don't know, because this could be the best of the best, top dollar paid to both houses here, but it just seems a little.
I think we should also, what's pertinent too, is if you look at the history of this principal broker and all the 5 charges against them, mostly for failure to supervise, including in 2022.
So, talk is cheap. I've got a motion on the floor.
Got one more question.
And I think that you might want to make a substitute motion.
I actually don't.
Maybe he does.
Yeah.
Joe does.
Joe, do you want to make?
Was this one of those cases where it was originally brought against the affiliate, and then we
that
made
was closed?
And that was closed,
right?
Because the supervision wasn't there from the principal broker.
This is a subsequent case. Principal broker after the initial case on the affiliate, and we closed it.
Original was closed, and this is merely just the
follow-up.
If anything, failure to supervise as it relates to his affiliate.
And the chair would like to speak to Ms. Frank's comments, who I believe said it looks like in the narrative the principal broker is trying to shirk his or her responsibility and pass it off to some compliance team somewhere. Did you say something similar to that?
I said those very words.
That caught my attention right there, and so I don't know if anybody wants to speak to that particular part of this complaint or not, but
I'd like to make a substitute motion to fine the broker here $1,000 for failure to supervise.
Second.
Now we have a substitute motion on the floor that, if passed, we'll be done with this complaint. If it fails, then we'll go back to the original motion, which is to accept counsel's recommendation and dismiss. So the motion for discussion, if anybody prefers to, is to offer a $1,000 civil penalty to the principal broker for failure to supervise. Discussion. All right, we're ready to vote on the substitute motion, $1,000 civil penalty. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. No. That motion passes on an 8 aye, 1 no vote. Ms. Torbett votes no. All right, we're on to number 33.
So this is a case about assigning options in a purchase and sale agreement. Or is that, could I say wholesaling? Is that another interchangeable term?
It's another term, right?
Okay. We've had a number of conversations over my service here about wholesaling, and the judge's opinion that you quote, he uses the word option. So in a purchase and sale agreement, if somebody's offering their option to purchase that agreement, isn't that
an option's different?
I know an option's different. I'm trying to nail down, the difference between assigning an offer to purchase versus an option to purchase. I mean, you're assigning your contract, which is assigning your option to another party, but you don't own the property that you're trying to sell. You just have the option.
Well, and unfortunately, the court didn't go into, they didn't define each individual, listing, sale, purchase, but we know they didn't talk about specifically assignment of contract. So at least from my interpretation of the case is that if all we have in front of us, which is just this complainant or this respondent who is admitting that they are assigning contracts.
But didn't we find a case in a previous about this very subject, and the Attorney General's opinion was that it was definitely unlicensed activity? That was just a few months ago.
I think this is the case.
I do too.
It wasn't Attorney General, it was the Court of Appeals.
Oh.
But Dennis is doing what he's supposed to do and trying to interpret what the judge said in that case, and it's not specific to this particular transaction. It's our issue.
Right.
And so the question in front of the commission is, do we want to interpret it differently than our attorney?
I don't think we want to backpedal on this one. This is so rampant. There's so many people that are out there. I mean, they're everywhere. People that are unlicensed doing this.
Just for the record, this is a case where a guy ties up a piece of property with a sales contract, and he has an option to buy it. Is that right, Dennis?
Well, in this particular instance, it was just there was just the assignment.
It's the option to assign it.
Is that in the contract?
We don't know because there was never any. For this complaint, there was nothing provided other than just the complainant's. Let me pull it back open.
Just the assertion, no evidence?
Right. I was trying to pull up what the complainant's blurb was very short. Complainant's also not a licensee. Not that that makes any, makes a huge difference, but just to sort of give a little more context.
It says that they're marketing and advertising and selling, but you have no evidence of that. They're assigning equitable title to real property.
And maybe this isn't a case to kind of hammer this detail out because you're dealing with an out-of-state investor and an unlicensed complainant with very little evidence to make a decision either way.
So is there any reason to change our previous decision on it then?
Have you had additional information from the respondent or discussion?
No. It was just a response saying that they're not engaged in anything but the assignment of the contracts.
I think without evidence to the contrary, I think we just need to. I'll go ahead and make a motion to accept council's recommendation.
Second. I've got a motion by Mr. Diaz, seconded by Mr. Nguyen to accept council's recommendation and close this case. Discussion.
I'd like to know why it came back up. Why are we rediscussing it?
We talked about it at some length at the previous meeting in West Tennessee, and not involving the case. And so when I went back to look at the prior to, because I think the original recommendation was $1,000 civil penalty, something to that effect, and settled by consent order. So before drafting that, I went back and looked at at what the complainant had said, what the respondent said, and then looked at the case that we really had not talked about, the Court of Appeals case that I note in the summary. And so that was why, without having talked about the case, I thought it was at least worth the discussion. And so as I began to read it over, usually you take out certain paragraphs of an opinion, I came to the conclusion that it just, the facts as we know it didn't really meet unlicensed activity. So that's why it's back.
So how do you discuss with anyone the assignment of a contract and not discuss the sale, the purchase, exchange, lease, or option? I mean, it doesn't happen like this. It doesn't happen like this. Advertising, I have an assigned option. Well, that's advertising. How are they getting it out? They can assign this option without discussing price, negotiating, advertising.
Having two closings.
I think we're, and this is a bad precedent that we're setting. We were so happy that we were able to. Where did this opinion that we previously had come from?
Well, before we had an AG opinion, but we had an intern year before last, maybe, who found this case.
This same case?
This is the case that everybody's hanging their hat on. Here's my dilemma. I totally respect Dennis's opinion on this, but if I vote to support his opinion, then I think we've opened the door to an avenue for all kinds of this
wholesaling without a license
to go on.
Yeah.
So,
I'd like to make a substitute motion.
All right, the motion on the floor right now is to accept council's opinion and close this case. Ms. Franks, what's your substitute?
I would like to make a motion that we stay our original commission decision to issue a consent order with a $1,000 civil penalty for unlicensed activity.
Well, or you could make a motion that we move on to the next item, and that would stay in place. I don't know.
And that one on my.
Oh, I don't mean the next item. I mean, you can say we're done discussing this. I have no motion.
Oh, gotcha. Okay.
Then we go back to the other motion and we vote.
Yeah, if
No, I'm not willing to do that.
Well, if your motion passes, then we're done with it.
Okay. All right. Then my motion will be that. Do we even need a motion then?
You really don't, but since we have one on the floor, if you want to make a substitute.
I'll make a substitute motion that we not take any action on this.
All right, the motion on the floor is to take no action on our previous decision. Is there a second to that?
Second.
Seconded by John. Discussion?
Just to be clear.
Yes, let's be clear.
This means that we revert back to our previous decision of a $1,000 penalty.
We don't revert back so much as it stays.
Got it.
Okay. So if this motion passes, we're done with the discussion, and the previous decision we made is in effect. Everybody clear on that?
This is a really important vote here, guys. Really important.
One comment. I don't know how we can know what we're really talking about unless we look at the documents. Dennis has not reviewed this option agreement or anything, correct? They haven't supplied it. So until you know what papers really say, how can you say whether it's an option or not, whether it's what the amount of money is, all the factors that go along with a real estate contract, and unless we've seen it, how do we know?
Well, Dennis, did you present this to us before?
Yes.
Yeah. This is not a new case. We've already made a decision on it.
But has he seen the agreements?
There were no agreements. There were no screenshots, anything attached to the original complaint. Now that doesn't mean that literally going online and probably doing a little bit of searching I possibly could find something, or it could be a situation like we talked about earlier about having an investigator do some of the research. Although I think most of it could probably be done just from an attorney level, because I don't know that an investigator is really going to be that practical here. I mean, it probably take more time.
I agree with Steve that we need to see what the agreement says. So maybe we just need to defer this until we have more information to be sure about it.
Allow me to play this out in my mind and for everybody to educate me or educate each other here. As Jeff, if you said today, if I am an individual in Arizona or Alabama or Arkansas, I think this one is in Arizona, and I'm an investor, and I know Tennessee for some reason. I went to college here. I know the neighborhood of Wedgwood, Houston. I'm just speculating. These are not real facts, by the way. But I live in Arkansas or Arizona, wherever. I have made a contract. I'm not a realtor. I've got money. I've got resources. I want to buy this property, Wedgwood, Houston. I got it under contract, but I know I can then sell it to somebody else and assign that to somebody else, make some money. I'm not representing somebody else. I'm not getting paid to do it. It's my money. It's my risk. That's okay, right? Without a license?
If you own the property, yes.
Not according to the Court of Appeals decision. You're in the process of meeting the definition of a broker, and that's what the Court of Appeals said. Now, where Dennis is looking at this is going, well, it lists a whole litany of things you can't do unless you have a license, but this particular item is not in that litany of items you can't do without a license. I mean, we're looking at one this little slice of that opinion. That's kind of the issue.
So Dennis. So the little piece that you've pulled out here that says defines a broker as an individual who deals or attempts to deal by negotiating the listing, sale, purchase, exchange. The rest of that is for other people, right? That's for people other than yourself.
Right.
So I think what DJ's saying is the way I've seen these, and the reason it's been legal is if I go to an auction and I think DJ and I are going to go in on this farm or something, and I just buy it as Joe and or assignees, then I can bring in other partners and add them as assignees, or maybe I can't get financing. DJ says, well, I'm just going to take it. So it's that legal part of, they're not an option, is I can buy it or not buy it. This is a contract. Somebody's going to buy it. It's me or an assignee. So I think, is that where we're kind of muddying the water? Or?
But we don't even have the contract to know if it says or assignees.
Right. So in a wholesale agreement
is, and we didn't discuss this at the previous meeting, we do have a snapshot of the advertising.
Okay.
I don't know if someone, this would be West Tennessee, so if one of the members would want to look at it from
if it's advertising at all, then he's acting as an unlicensed agent.
Unless he owns it.
Does he own it?
Although it doesn't say that they do own it. All it says is that here is this piece of property, starting price at this amount. Click here to get this deal. If you're interested in taking the next step, you must click the button above, and it gives a description of the property, address, 2-bed, 1-bath, and then a price, a number, contact, some dude.
Joe,
I'm comfortable with my motion that we do nothing on this and we leave it the same.
We'll get to vote on it shortly. We're discussing.
Joe, would you, if you saw that, would you think that person was a licensed real estate professional? If you saw that ad, or based on what you just heard.
I mean, the question. Well, I think if Joe or the consumer, what does the consumer know?
Okay. Would if a consumer saw the ad that as described just then, that's my point. That sounds like somebody who's in the business of real estate.
And then to go a bit further, let's keep playing with the example. The wholesaling is somebody owns a property that they are selling. An investor comes along and puts that property under contract. And instead of consummating the deal and closing on that deal, they are going to go and sell their interest in that property to somebody else, which would require a second closing. Right? Otherwise,
maybe not. Maybe not.
But there's going to have to be some
simultaneous.
It's going to have to go on to consummate that deal. Mm-hmm. So that is wholesaling. That might, and is that unlicensed activity? And that's the question that we're asking. Is that act of holding out that now binding purchase and sale agreement that you're in, your option to buy that property, is that selling a property without a license or unlicensed activity? And that's the question we're asking with this case.
And this is a nationwide
this isn't a
discussion
Tennessee
going
problem.
on. It's not just Tennessee and
Yeah.
Arizona.
All right, let's do this. We have two motions that are properly on the floor. One is the main motion, which says to accept council's recommendation and dismiss this case, and the second is a substitute motion that says let's take no action and move on to the next case. If that motion passes, which we'll vote on first, we're done with the discussion. If it fails, we'll go to the main motion, which is to accept council's recommendation. I haven't asked Caitlin to do a roll call vote in a long time, but I think this might be a good one to see if you're still up to it.
I'm up for it.
Okay, if you vote yes, this is on the substitute motion. If you vote yes to this motion, we're done with the discussion. If 5 or more people vote yes to this motion, the motion is to move on to the next case, which leaves our previous action in place.
Which was a consent order with a $1,000 civil penalty for unlicensed activity.
Right. So if you vote yes, you're ready to move on to the next case. If you vote no, you're ready to discuss the main motion, which we will go to if this motion fails.
Okay, Commissioner Begley.
Yes.
Commissioner Diaz.
Yes.
Commissioner Ferris. Commissioner Franks.
Yes.
Commissioner Gwynn.
No.
Commissioner Moffitt.
Yes.
Commissioner Smith.
Yes.
Commissioner Torbett.
Yes.
Chairman Grease.
Yes. So the motion passes on 8 aye, 1 no vote. Mr. Gwynn votes no. All right. Next case on our list is number 35. And Dennis, this is the last case on your list, but it's one we had before where we had a commissioner come up and look at an ad, and the ad wasn't really there. Is it there this month?
It is here today.
So I'd like for that same commissioner, Commissioner Begley, he's going to recuse himself from this vote to go tell us what you see. And the question is the agent's name larger than the company name? Is that the question?
It's the same questions we've dealt with before.
Is this the ampersand
No, I don't know.
case?
I don't know on this one.
We've had an ampersand
Yeah,
case.
yeah, we have. His eyes are. Wild eyes.
I think it was the one who wanted up and counted for continuing. No, it was somebody.
We hope not.
You need some Advil? Let me see.
All right, Mr. Begley, why don't you report from there? We'd like to look at you from a distance. Tell me what you saw.
Microphone.
In the microphone, sir. State your name, address.
My name's Joe Begley. I think it's fine. In my opinion, that doesn't sway me, to think that the agent's trying to make his personal stuff larger than company stuff. There's a team name at the top, then there's an agent name somewhere in the middle, and then there's some company stuff at the bottom. But to me, it's in compliance.
Any questions for Mr. Bagley? It's your belief that the team name is no larger than the company name?
Correct.
And the agent's name is no larger than the company name?
Correct.
Is there a motion?
Move to approve.
Is the may I ask, is the firm like is it a well-known firm, or is it like a small
Well-known.
national, maybe? I don't know, I'm just.
Does that matter?
It's a
just
franchise.
just asking if it's
Franchise.
Can I say that?
if it's a franchise, yeah. And it also, I mean, in the team name, there can't be realty, or there can't be what else, I mean, what all can't be in the team name? Is that a problem?
I don't think so.
Okay.
You would be okay with a motion to close this case and dismiss it?
I would.
I'll make that motion, Mr. Chairman. Motion to dismiss.
A motion by Mr. Diaz, seconded by Ms. Franks, that the case be closed. Further discussion. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no, and the motion passes unanimously. Thank you, Joe, for putting your reputation on the line.
Anytime.
Okay, good. We'll remember that too.
Mr. Chairman.
Yes.
Should that be an 8-0 with one abstention?
I'm sorry. That's eight ayes and one abstention. Mr. Bagley abstains. All right, number 37. Anna, thank you, Dennis, first of all. Appreciate you putting up with us and going through all that minutia to get us a succinct report.
Thank you, Dennis.
Okay, Anna, we're on to number 37. Ms. Franks?
Number 37. I had a question. Was this a clerical error on the buyer's representative agreement? Or do you have the buyer's rep agreement?
One second. Let me see if I have the buyer's representation agreement. I do not have a copy of the buyer's representation agreement, but I do have a copy of an affidavit from the buyer attesting to the information. Yes.
Okay, so you didn't see anything fraudulent or anything about this?
I did not.
Okay, I move to accept council's recommendation to dismiss.
Motion by Ms. Franks, seconded by Ms. Torbett. Accept council's recommendation. Those in favor of that motion vote aye.
Aye.
Those opposed, no, and that motion passes unanimously. All right, number 46. Is that right, 46?
Yeah, you said
Okay.
46.
Okay.
You've been taking notes.
So I'm confused on this one. It doesn't take much for me to be confused. This is a complaint against the principal broker for failure to supervise. However, the firm was the subject of the complaint to start with.
Yes.
And so the logic is you can't supervise the firm, only your affiliate brokers.
Right, so if you look at the failure to supervise, it talks about failure to supervise the activities of an affiliate broker.
So this was administratively opened, right?
Right.
Did we open it against the wrong party?
No, I think that because that was a mistake of mine in the one before. So when typically when we do not have an individual that does not respond, we open a complaint against a principal broker. But that's usually in the case of affiliate brokers. But in both of these cases, I think this happened in 47 as well. They were firms. And so both of the firms paid for the failure to respond. And when you look at the failure to respond provision in the statute, the failure to supervise would not qualify, wouldn't work.
Just that was a technical question.
Yes.
All right, Sheriff's ready to accept the recommendation to accept council's.
I move to accept council's recommendation.
Okay. Mr. Diaz seconds that motion. Discussion. Those in favor of the motion vote aye. Aye. Those opposed, no, and that motion passes unanimously. Let's do this. I'm going to make an effort to see if we can get some heat in this room. So let's take a 10-minute break. Then we'll come to your groupings, and we'll be back in session. Look at your watch. Come back in 10 minutes, and we'll get started.
I've got icicles coming out of my nose.
I can't focus all the chattering going around the teeth. Audience, I want you to think you're warmer than you were before the break, okay? Just convince yourself you're warmer.
Think about being in the desert.
Yeah, in the desert.
Think warm thoughts.
Before we get back to the cases, I'd like to introduce Mark Green, who's in charge of the attorneys here in front of us today. Mark, come up here. Mark and I like to talk to each other, and as a recognition of my last day, he's partially shaved. He used to have a whole full beard. It looked terrible. Now, yeah, we can't hear you, Mark. I'm glad you're down here because I'd like to brag on your attorneys for a few minutes, if that's okay. Both of these two are doing a great job, but I think they're understaffed. I think they need more help.
I agree.
Well, what are you going to do about it? That's really what the question is.
Well, we certainly are down one.
Push that button. I can't hear you. I want you to get on the record committing to do this.
Can you guys hear me?
Yeah.
Yes, we are understaffed. We're understaffed one attorney on the Trek side, and we are currently interviewing. We thought we had one identified that fell through, and so we continue to interview and go through the process. So, but I want to echo your comments that Anna and Dennis have certainly, and Carol, our paralegal, has certainly taken a lot of extra work on and have not dropped a beat, and they should be recognized for that. And I'm glad that you have positive thoughts about them, because we certainly do here at the department.
They're good people, but I've noticed in the past, over my tenure here, that good people get recruited away. So can you give them more money or something to keep them here and not move?
There's a real simpatico going on because they have learned us, we've learned them, and it just seems like everything's just going so smoothly with this group right here.
I'm not sure what simpatico is. Mark, you're an attorney. Can you tell me what that means?
I think it means whatever it means, it's good.
And that's an attorney answer.
Yeah, I know. Well, thank you for stopping by and letting us brag on them for a minute.
Mr. Chairman, I'm going to miss seeing you regularly, and want to wish you well. I know you're not retiring or anything, and but we won't be seeing you. I think I've been here 12 years, and I think 10 of those you and I have worked together, You go back to almost the original bunch that I worked with. Just want to say how much I appreciate your leadership to the board as chairman and all the things that you've done, and always been real accessible when we needed to have a conversation about something. And sometimes we know those conversations are a little more difficult than others, but we've always appreciated your professionalism. And I'm going to stop because I didn't wear boots today, and it's getting a little thick. So,
yeah, as long as you commit to giving these people a raise, I'm okay with everything else you said.
Doing everything I can.
All right, pal. Keep it up. Thanks for coming by.
Thank
Mark.
you, sir.
It's been a pleasure. Mark used to be Anna a long time ago. I mean, he started as a staff attorney with the Real Estate Commission. Has worked his way up. He's done a great job. Thank you, Mark. Take care.
Thank you, Mark.
All right, Anna, we've you get at the last minute, and probably for good reason, you gave us a package of complaints that you want to break into two groups. Complaints 50 through 62. Let's talk about that in general and tell us what we have.
Yes. Okay, so let me start by reading, I'm just going to read through. I think that'll help everyone pretty quickly. So complaint numbers 50 through 62 are together. So on or about November 8th, 2021, the Commission received multiple transfer, release, and change of status forms, or TREC Form 1s, from respondent choosing to broker release 13 different affiliated licensees. Following this action, the Commission administratively opened 13 complaints against respondent for failing to adequately exercise supervision over the activity of these affiliated licensees. Specifically, respondent failed to ensure that all affiliated licensees maintained continuous errors and emissions insurance coverage. In response, on December 1st, 2021, as required by Tennessee Comprehensive Rules and Regulations 1260-01-.162C2, if a principal broker releases an affiliated licensee more than 120 days after suspension, the consent order shall contain a civil penalty of $1,000. Therefore, counsel sent respondent a consent order authorizing a $1,000 civil penalty per affiliated licensee for a total of $13,000. On November 19th, 2022, counsel filed a notice of hearing and charges with the Tennessee Secretary of State's Administrative Procedures Division for these matters to be set for a contested case hearing before an administrative law judge sitting alone on behalf of the Commission. Errors and omissions complaints along with unlicensed activity are two of the matters that have been delegated to the administrative law judges to be heard on behalf of the Commission. During the proceedings, counsel for the Commission informed respondents' counsel that they are permitted to anonymously present the matter before the Commission for consideration. Tennessee Comprehensive Rules and Regulations 1260-01-.162C4 provides that nothing in the rule shall be construed as limiting the Commission's authority to authorize a consent order in a different amount than listed herein, seek additional legal discipline, including revocation or suspension of a license, for failure to supervise an affiliate licensee's E&O insurance, review an initial order under the Uniform Administrative Procedures Act, or not seek discipline against a principal broker for failure to supervise an affiliate broker's maintenance of E&O insurance if the Commission determines that such discipline is not appropriate under the facts of the matter. Counsel has provided a copy of the statement from respondent's counsel with all personal identifying information removed. So if you'll see the document that I have provided to you, it is the second stapled document that you'll see. It begins. You'll see at the top, it says, it should say June 1st, 2022. So I'll read this. It says,
just before you do that, just
yes.
so I stay clear, is this in front of an ALJ now, or is this designed by this attorney to preempt the hearing?
It is before an ALJ, but we have not had anything yet. So the only thing that we've had so far was a pre-hearing conference. We explained during the pre-hearing conference that we were going to attempt to settle the matter by presenting it before the commission. And then after this presentation, we would follow up with the judge to let her know what would happen and proceed after that.
The crux of the complaint is that this broker released these licensees, but it was a little too late, more than 120 days after they'd failed to buy E&O insurance.
Yes.
That's what we're dealing with.
Yes.
Okay.
And did the principal broker release them because of the insurance?
I believe so. Yes. So they were broker released in November of 2021.
On to the letter now.
Yes.
Okay.
So the letter says, Dear Ms. Matlock, I write in response to your agreement to present redacted position on the conduct alleged in this matter before the Tennessee Real Estate Commission at the upcoming June public hearing. The response understands that this presentation will be anonymous. Please present the following points to the commission during the June hearing. Respondent has been a licensed principal broker employed by the same company for over 16 years. Respondent has never been subject to any discipline by any local, state, or federal agency. This contested case represents first allegation of misconduct by the commission since respondent obtained a principal broker's license almost 2 decades ago. The commission alleges that respondent failed to maintain errors in emissions insurance for 13 individuals over the past 7 years. Respondent contends that the appropriate paper or online forms were timely submitted for each of these individuals, but that such documentation was not correctly processed by the commission. Respondent is being charged with violating the commission's rules despite being advised for some of the employees identified in the notice of hearing that all of the appropriate forms were received and processed. Respondent released 4 individuals from respondent's roster in 2019 by submitting the paper Trek 1 forms. Upon an email follow-up to the commission, respondent was informed by a regulatory board administrative assistant, quote, received Trek 1 forms and it all taken care of, unquote. The commission now claims that these forms were never received and the respondent should be subject to discipline for failure to supervise these individuals. Respondent pointed out other failures to the commission as well. For example, an individual was placed into retired status and the appropriate fee was paid by check, which was cashed by the commission. However, this individual still remains on respondent's roster. Respondent raised this discrepancy in 2018. In other instances, respondent broker released individuals using the online system, but these individuals remained listed on the roster for respondent's license. In other circumstances, respondent broker released individuals using the online system, yet the roster shows that only some of the individuals processed on a particular day were released. In another instance, one of respondent's employees was suspended due to a lack of E&O coverage, but after respondent resent the E&O roster showing the employee's name listed, the Commission removed the suspension. All of these issues outlined above show that the Commission has not appropriately processed the broker releases or other changes of status for individuals employed by respondent over a significant period of time. Yet the Commission seeks to fine respondent more than $10,000 for the lapses that appear to be the result of a glitch or process failure within the Commission. There have been no complaints lodged against respondent or other claims made that would have triggered E&O insurance for the individuals at issue. In other words, there has been no breakdown of the consumer protection goals of this rule. While there are undoubtedly unscrupulous individuals that routinely fail to maintain E&O coverage for individuals in their employ, respondent is not such a person. Respondent has a spotless record and is not at fault for the issues outlined in the notice of hearing and charges. Respondent requests that the Commission dismiss this contested case with prejudice and no longer seek to sanction respondent or collect any penalty for lapses that were likely the result of an error of the Commission's own systems or processes. Thank you for agreeing to raise these points with the Commission. We request that you read them verbatim and that you do not summarize or attempt to characterize these points. If you have any questions or require anything further, please feel free to reach out to us. We look forward to a full and fair presentation of redacted position at the upcoming hearing. Very truly yours.
Thank you, Anna. What are our options in a situation like this? Can we honor this attorney's request and dismiss all the cases?
Good.
Can we ignore the attorney's request and let it work through the ALJ?
You can.
Are there other choices we have?
Yes, but I also have a response.
Oh, okay, perfect. I'm sorry.
So it is on page 6 of the document. It is the paragraph under the new information. It says it begins on the second paragraph. In response, Counsel provides the Commission the following information. To date, the Commission contends and maintains that the TREC Form 1s in question were not received. There is no record through the mail or online for the TREC Form 1s of the affiliated licensees in question. There are no open online core transactions related to the affiliated licensees in question. Further, official rosters are with the Commission. It is the responsibility of the principal broker to ensure and maintain this is accurate. Respondents' counsel also mentioned several inaccuracies from the number of individuals allegedly broker released in 2019. I would like to retract the first part of that sentence, but however, I will say counsel cannot verify that the identity of an individual that is allegedly retired. As of June 2nd, 2022, respondent had 138 licensees affiliated with their firm. Therefore, due to the significant number of licensees, counsel and staff are unable to verify this claim made by respondent's counsel. Principal brokers are tasked with ensuring to adequately supervise all activities of affiliated licensees. This includes guaranteeing at all times that licensees affiliated hold E&O insurance as required by the rules and statutes. Additionally, this includes completing all required administrative measures. Supervisory responsibilities of principal brokers do not terminate until the Commission receives the TREC Form 1s through hand delivery, through postal mail, or online submission. Statements accusing the Commission staff of incorrectly processing forms are certainly possible, but to present knowledge of all gathered and presented information from the Commission staff, respondent and respondent's counsel thus far, this is untrue. The Commission staff corrects errors as the information is presented. Counsel contends it is very unlikely 13 affiliated licensees broker released on different dates were due to the result of an error of the Commission's own systems or processes. Based on the information provided in the statement from respondent's counsel, counsel for the Commission finds no specific or material evidence supported by respondent's counsel to support dismissal of the open complaints. Since I wrote this information, I was made aware by Mark Green of an email that did support that one of the 13 broker release forms was submitted by the email that was submitted. But I do not have emails that are supported by the 12. But none of that information was submitted to me personally, but I received it about 30 minutes ago. But otherwise, I worked with Rihanna extensively on this after receiving this information back to verify the information, and unable to find any open online transactions related to this. It's been stated that that the information was sent to us via the mail. We have FedEx tracking information, but we can't trace what documents were sent with that tracking information. And all of the different forms were sent at different dates. So at this point, there is a large time span over when these 13 individuals were affiliated with respondent's firm. So.
Right, Joe.
Triggered the them to send these 13 releases on November 8th. What was previously? I mean, had we started finding them on some of these people, and then they went through their records and just decided to release everybody at once? Or, I mean, what made them all of a sudden on November 8th go through and release 13 at a time?
Hold on one second. I want to see.
Caitlin, so if a broker is releasing agents online, when they complete the process online and they click send or submit or whatever, they get a screen afterwards that says that their form has been received.
Correct.
And they get some kind of receipt.
Correct.
That says their form has been received. So you don't have anything from the respondent that says, I got these 13 receipts that says you
I think this respondent is claiming to have FedExed these or emailed them, which I have tried to make a point at any of my outreaches or any opportunity to suggest that all principal brokers submit them online through CORE, because it does allow for that receipt where it says the broker release request was received, and it includes the licensee's name on the request. And so, because like Anna said, when we do receive proof or something of that nature that we might have made an error, we always do correct it. But I always say not to email them and not to mail them, because these don't have any money attached to them. So, you know, we only have so much control. This comes to the building, and also we don't know what was in that FedEx. You know, it's
13 tracking numbers, but no idea what the inventory of the package was.
Exactly. And, you know, there's other things that are sent via FedEx too for firms. So it's very hard to determine what was in that, especially when it doesn't have money. At least when it has money, we can track it by the check number, and that will be put in our system. But mail that just...
So did it come in did all 13 FedEx packages?
I think that they are suggesting that these were sent over a span of a long period.
Right.
I think even 2018.
Of the 13, 9 were sent in 2019. The oldest one was supposedly sent in 2014. So they're sent at different dates, but all of them are paper forms. So they would not have been submitted through an online system.
So did they provide you the tracking numbers for the FedEx?
Tracking. I have some tracking numbers for FedEx. Have confirmation from it. But it can say that it's been delivered to the department, but I don't know if it's this particular document. But also I'll say that if a document was delivered in 2019 and we're just now realizing in 2021 that the person is still affiliated with your firm and hasn't been removed.
So, and the respondent did not maintain their Trek 1 forms, a record of their Trek 1 forms for themselves?
The forms that they submitted to me are the ones that they stated that they kept.
I have no idea if they were contemporaneous to the actual release generated yesterday.
Only through the respondent's word.
Only through the respondent's.
So as a principal, that if I broker
Sure, your microphone's on.
As a principal broker, I can say that if I broker release someone, that is information I want to make sure that my date is on there and I was cut off that day, so I'm not responsible for those people anymore. I don't know how this could have gone on since 2014. Well, I mean, what happened to make them? Did they get? They got this from us saying you owe $13,000, and
I'm not exactly sure why the broker release forms were sent. I think it had to do with the E&O suspensions, because I know it wasn't just these that were submitted. But this was during the E&O cycle. So these weren't the only individuals.
Of these baker's dozen that we have, these 13 licensees, do we have any record of them landing at another firm using a Trek 1?
No.
So Trek 1's from this respondent, and they vanish from the record after that. They're
and only else. This respondent.
Oh, I haven't checked in a while, but most of them did not. I did not find another firm that they were affiliated with.
Wow. Okay.
So, if I thought that I'd already released them, wonder why I released them again on November the 8th.
Yeah.
I thought they were gone already.
So the only, so we do a suspension monthly. We are on the middle of the month running a suspension, and so the system looks at all licensees and whether they have active E&O insurance. And so it could be that some of their other licensees, because not everybody has the same renewal policy period, it could be some of their other licensees, because what the commission does is we do send letters when a licensee is suspended to their firm, to their principal broker, and to the address they have on file with their license. And so it could be, being the key word, that some of their other licensees were suspended for the first time at that time period, and then the PB went back to do a compliance check of all the record and realized that they had all these other licensees that were also in a suspended status with their firm.
It looks like they would have some proof. I mean, we have no proof that they sent these in. So it looks like they would have the proof that they had. copies. I would have put a FedEx. I would never FedEx, but if I was going to FedEx, I would certainly put that on there, the tracking number, everything, in case something ever came up about this person that I'd released.
The proof they submitted to me were the forms and the FedEx information.
And they were signed. You could tell the signatures were all different across those different dates, or did it look like somebody did them all in one day?
They were some were on the same day, some were on different days. It's difficult to verify scanned forms. But I'm also I'm not a handwriting expert, so I can't really do that either.
Like the 2014, which is the oldest one, what is their license status?
Their license status at this point, it's expired.
Back in 15 or 16, correct?
Right, correct.
So they've not been on a roster since 16 anyway.
Their license was expired, but I don't think they're technically...
Like, did their license and their E&O expire at the same time? Or
Once you're expired, you obviously aren't required to maintain E&O insurance because you don't have an active license. So,
do you know if their E&O and their license kind of expired at the same time, or were they active for a while without E&O on those old ones, or is that irrelevant or not?
But the ask today is from this attorney, is that we dismiss these contested cases today, right? So doesn't it make sense to let, to me it just seems like the proof needs to be shown and heard, and otherwise I don't know why we could come up with making any decisions. Because we don't have any of the proof before us. We only have what the commission's staff has told us and what this attorney has told us. So, I think the proper thing to do is let each one put on their case and their proof, because that's what we need is proof.
So right now this case is out for an ALJ to handle these cases.
Right. So if we don't have a decision today, then I would talk to respondents counsel, see if we can come up with a decision. If not, then update the judge and we go from there.
Steve, I have a question.
So, Anna, let's kind of walk through the scenarios here. So, right now, the 13,000 is now to 12, right?
Not necessarily.
Not necessarily.
Well, okay, it's 13,000. So the broker can pay at 13 and the thing goes away, correct?
Yes.
His other alternative is to go to the judge, go to the ALJ route, which is going to cost money, right? He's got to pay an attorney and all this. And how does that work?
Well, they already have an attorney.
Okay, so he spent some money already.
Correct.
But he's probably thinking that he doesn't have great evidence. Otherwise, he'd give it to us. So, it's probably a loser. And I mean, we don't know, but without going through it, I'm just trying to understand why they don't pay the 13,000 and move on down the road. I guess they're trying to save 13,000. This is a deal out of left field, or I mean, what do you think?
I can't really speak for them, but I know that $13,000 to most people is kind of a lot of money.
Right.
So that might be it. Or also, very adamant that the forms that they submitted that their evidence and the tracking information they think that is enough too. But I can't speak for their decision.
So Marcia's point of bring on your evidence, I think that's the way to go. It seems to me like we can't. Can we base a decision on a letter that you read? I mean,
Right. Well,
That's the first step always with a lawyer is a letter.
Give it a shot. Yeah.
Well, it's an it's always an option to, and the only way you can do it is anonymously, since we're bringing it before the commission. So why not try?
Right. Are you going to make a motion?
Let me ask one more question. Are you prepared to acknowledge that it's 12, not 13, based on what Mark Green told you?
I'm gonna double check on the email. Like I said, I got it 30 minutes before this started. And once we can verify that it happens, if it is true and it's fine, I will gladly drop it to 12.
That it could be dropped before it got to the ALJ as well, right?
We can amend it. I can make an amendment to the notice of hearing and charges. Yes.
Steve asked you if you're ready.
So if they're wanting an action by this commission today, my motion would be is that we go forward with the process and make no decision today. That's my motion.
What about deny? I think he's asking for is he not asking for an answer to the letter?
We're not required to give him an answer to the
We're
letter.
not?
No.
All right.
If the motion, if we get a
That
second
would be
to-
the answer to the letter.
Right.
If I get a second to Marcia's motion, which I just did, the intent of the motion is to let all parties know that the process that's been started should continue.
Right.
All right, that's the motion on the floor. Any other discussion? All right, let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. And the motion passes unanimously. Thank you, Anna, for getting us through that little batch of cases. And we have one more, 63, 64, and 65. They're all related, yeah.
Yes, so these are represents. So the matters were presented to you in February, and I'll read the new information, and I'm happy to answer any questions afterwards. Following the meeting, counsel for the commission sent respondent a copy of a consent order authorizing revocation of their real estate license. Later, respondent and their counsel contacted counsel for the commission in an attempt to cure and settle the outstanding complaints with the commission. Counsel for the commission reiterated to respondent and their counsel the importance of keeping the commission appropriately apprised of the status of a firm's escrow or trust account as required by statute. While respondent made further attempts to collect documentation related to the banking statements of an escrow account and failed, respondent did aver under penalty of perjury that, to the best of their knowledge and belief, respondent maintained an escrow account at either of the two banking locations mentioned in the audit. Following negotiations, counsel for the commission recommends respondent's license be downgraded from a real estate broker to affiliate broker for a term of 3 years. Upon completion of the 3 years, should respondent intend to upgrade their license to a real estate broker, respondent shall appear before the commission with their current principal broker for a determination of whether respondent shall be permitted to continue to upgrade their license. If respondent receives approval, respondent must first complete the 30-hour office broker management class and real estate broker examination. So my recommendation is license downgrade for 3 years. Following the downgrade, the respondent must appear before the commission and receive approval to upgrade, complete the office broker management class, and to pass the real estate broker examination.
Motion to accept council's recommendation.
Let's get a motion on the floor. Is there a second? Seconded by Ms. Torbett. Now discussion.
So, I would like to ask, you're basing this, we just got this today, so we haven't even been able to read. Can you refresh our mind about, this was obviously escrow account problem, and must have been very severe if we revoked their license.
Sure.
And so now they've come back to you and said We don't have any kind of bank statements to prove it or anything. All we have is our word under penalty of perjury. And for that reason, you're saying instead of revocating them now, we should let them be an affiliate broker.
So they were unable to provide the specific banking statements that have like the ledgers, but they did provide banking documents that did state that it had an escrow account from 2 documents that were from 2019. They don't have continuous documents for the time period. They also, for their firm at the time, had a policy that stated that the escrow account was being held elsewhere by an outside entity. So my explanation was that instead, there should have been a waiver, an escrow waiver, for a third party to hold the account, the escrow account. And so I explained to their counsel that we didn't have that information. And so therefore, that's what the violation is based upon. And they don't have any documentation to show me that that waiver was on file with the commission. And so that is based on what the information is here. I don't have any record of an escrow account or an escrow waiver.
So why couldn't they get it from the bank?
The bank? The bank was unable to find any documents. When our
so does that mean there were no documents?
The bank didn't have documents. We couldn't, the auditor was unable to have documents, and then they were unable to get documents.
So there's no proof that they had escrow accounts.
But I do have the 2 banking statement, like the 2 banking documents. I don't know exactly what you would call them, but they are official bank documents that do state escrow.
So like mine is, I have Franklin Realtor's operating account and I have Franklin Realtor's escrow account. Is that what you're saying, that company had?
Right, let me pull it up so I can show you, so I can read what it says to you. So it says a banking document here at the top, and it says a page number, a date of June 30th, 2019, and account number. It has the firm name, and under it, it says escrow. And then it has the firm location, the address. And then it states, I don't know what this is. What is that? I guess this is a type of account it's called. Account number, and then it says summary of activities since your last banking. So it's a banking statement for June of 2019.
Was there any activity?
There was an activity on it.
So remind us, what was the violation to begin with, since we've not had time to even read this?
The violation that I brought to you originally in June was the escrow, failure to have an escrow account, because I could not find one when we were doing the audit. There were several other allegations of mismanagement related to the escrow account, but the violation that I brought specifically to the commission related that the discipline that went out on is for the failure to have an escrow account or an escrow waiver on file with the commission.
So their only proof of having one is that piece that you have that with no activity in it, right?
I have this banking statement for June and one for July and August. 3 for 3 months.
21?
2019.
And are there balances in there?
They're both empty.
So the audit requested copies of respondents' bank statements, including the general escrow account and any other accounts maintained by respondents, copies of wire transfers, bank reconciliations, copies of commission checks and payments, a list of outstanding checks and deposits, copies of the journal or check register, and an explanation of any withdrawal or transfer of funds to the escrow account. And we didn't get those things.
Did not get the full documents, no.
So what of those? We didn't get any of those things except the one piece that you have there?
We didn't get all of those documents. We didn't get any of the documents for the escrow account. We did get some of the documents.
So no bank reconciliations. I mean, I've been audited by the state of Tennessee, and I had to provide all of that stuff.
It appears the statements you're receiving don't apply to these closings.
Because the problem was that a complainant realized that their deposit in the firm's escrow account, when they were returned the money, it bounced. The check bounced.
Yes.
So there was no money in the account, even though the buyer gave them money to go in their escrow account. There was no. They were writing hot checks out of their escrow account.
I understand, but that's not what the discipline is based upon. For this particular complaint, based on the information that was found following the audit report and the investigation that we did and collection of documents, this is the route that we chose to proceed.
So after the audit, and you got all of that information, the commission voted to revoke this licensee. The only new evidence that you have been given is under penalty of perjury that, to the best of the respondent's knowledge, that they did maintain an escrow account.
I'd like to clarify, when I presented this matter to the commission in February, the audit was not complete at that time.
Why was it presented?
The reason that it was presented is because we found that the respondent at that time, we did not have proof of an escrow account. And we thought that
It was egregious, yeah.
That it was egregious. And that was why we brought that matter to the commission. And then we proceeded with the rest of the audit report. And that, following the report and the conclusion, that is still the method that we decided to choose and is still going to be the legal pathway that I am going to continue to move forward with after it. And so, based upon that, after I spoke with their counsel and they provided more information and background about the escrow account and how that they did not actually hold the funds, and that information, my understanding was that revocation of the license, my intention was, in order for the respondent to downgrade her license, was for her to not be able, or this person to not be able to hold escrow funds for a period of time due to the issues that were presented here in the complaints.
Is it possible to say that this person could never be a broker again? Can't do that, can we? Okay, so now they're revoked right now. But they've
Yeah.
not signed.
No.
So they're
No.
not officially revoked.
Not if it correct.
So they're still out there, and who knows if they got an escrow account today or not.
Their firm is not open. They're not
Okay.
working as a principal broker. They're
Okay.
working under another broker.
So, so if in their time as a principal broker for the time period in question, they had a third party, they contracted with a third party to hold their escrow funds?
Yes.
So that could be why those escrow accounts at that time are empty, because they're not holding funds themselves.
Correct.
So checks were written to this company, and then they turned that check over to a third-party title company lawyer or something,
So-
instead of the checks being written directly to the title company or the law firm, right?
It states here, I'll read this one statement. It says, our policy is that the title company / attorney hold the earnest money instead of the firm. Like, this is a copy from their, I guess, firm manual information. And it explains under state law how the money is supposed to be handled and provided to their holder of the funds.
So were the checks written out to the holder of the funds or to the real estate company?
Which checks?
Any escrow checks?
I don't have that information.
See, I can see it. I have a builder, and he wants his deposits to go to a law firm. And I have this, written agreement with the law firm and with the builder. And so the checks are made out to Hell and Hale. They're not made out to Franklin Realtors. So it would be a problem if they were made out to Franklin Realtors. Then it was my having to turn it over to a law firm. That's what I'm wondering. Were they doing that instead of letting them go directly to the holder? Because the money's missing. They weren't able to write this person a check. They weren't able to.
So, Anna, the only thing that's confusing to me is Marcia mentioned a hot check. I guess somebody didn't get their escrow money back, or wasn't. Is that right?
That's where the complaint came from.
Or did this
An
come from an
agent not getting a
investigation?
commission check.
An audit.
Yes, that was one of the original allegations in that matter is, to my understanding, being handled civilly outside.
Well, my question would be, did the escrow, the company that was holding the funds allegedly write the bad check, or did the broker act like he or she had those funds and she wrote the check, which caused the civil matter? I'd love for you to.
There's already.
Yep, he made it.
Oh, you already made that?
Yeah.
Okay. And it's been seconded?
Yes.
Okay. Then I don't
Not
need
sure
to make
about
a
who.
motion.
Other discussion? The motion on the floor is to accept council's recommendation, which would have the effect, and doesn't make it happen, but offer to the licensee a downgrade for 3 years with conditions.
Let me ask you this. So they're revoked right now, but
No.
not until they sign the consent order.
They've just been offered.
So it's been, okay. So at this point, if we go forward with it, then they're going to have to come before us, or they're going to have to agree to the revocation. That's what we have right now, correct? And so if we change this and we say we're going to downgrade you to an affiliate, in 3 years, they can just, like nothing ever happened, go through the process and become a broker again, right?
After they have to come to a peer.
No, so if my recommendation would be that right now their license I sent them a consent order with the recommendation of revocation. So this is a settlement offer to the consent order instead. So my recommendation is, instead of revocation, it would be a 3-year downgrade to affiliate broker. After that 3 years, the respondent would be, if they choose to upgrade their license to broker, they would be required to appear before the real estate commission with their principal broker at that time. And at that time, the commission will then make the determination whether if they can proceed to take the 30-hour class and test for broker. If they were to say yes, they can move forward. If I added this stipulation, if the commission says no, then they would have to wait an additional 3 months before they come back the next time.
Okay, but I don't see that on here. It just says license downgrade. I don't see anything about the 3 months.
That was a summary, sorry. It's in the consent order, I promise.
So did they offer this deal to you, or did you offer the deal to them?
They made an offer to me, and then I made a counter offer.
Oh,
this complaint initiated from a commission check to a licensee internally in an office, nothing to do with E&O initially, right?
Yeah.
It says that they didn't deposit the commission check.
How about Joe?
So, I mean, the first paragraph doesn't talk about E&O or trust account so much.
Right, we're not.
2 years later, she files a complaint and throws the trust money out there.
Yes, we're not talking about E&O.
Trust money.
Let's grow.
We're doing a lot of E&O today. So it wasn't initially about a commission out of their general account. Trust fund money.
It doesn't come out of an escrow account.
It doesn't have anything to do with a third-party title company either. I mean, so.
But based upon that information, we decided to do an audit of both of the operational account and the escrow account, and then at that time we found out there wasn't an escrow account.
Hi, Commissioners. Did
that answer your question?
Call the question, Mr. Chairman.
Okay, we have a request to call the question, which is non-debatable. So the question is to accept council's recommendation. If there are less than 5 votes, we'll continue the discussion. If there are 5 votes or more, we're done with this topic. So without objection, we'll try a voice vote and see how this goes. The motion is to accept council's recommendation, which includes but not limited to a 3-year downgrade of her broker's license. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no.
No.
And that motion passes on an 8-1 vote. Ms. Franks votes no. Thank you, Anna. I know clustering or grouping complaints causes one to put their hand over their face and rub their eyes sometimes. I'm just talking out loud. The good news is you've got, by the way, to the audience, we're going to work through lunch, all right, which may take a little bit longer, may not. We'll just have to see, but don't be thinking you need to break for lunch. We're not going to. Okay, next up is to talk about some rules updates, which are black and white and red in front of us.
Yes. So which set would you like to talk about first?
I would like for you to take charge and you pick it.
Okay, so I would like to talk about the timeshare rules first. So these rules are in direct response to the passage of the new law. So it required amendments to the information about disclosure of rescission rights. So if you look on your iPad, you guys have a copy of it. So essentially what I did in this particular section was I marked out the whole section here, and I wrote a new version of it. So what you'll see differently here is that, first of all, I numbered the first statement where it says the statement in 1260-06-.04 2B1. states it shall appear as written in boldface and conspicuous type in. And so A and B are the same. The changes come from specifically in section I. So the statute changed by adding subsection 3, the part that states that you are permitted to submit cancellation via email. So prior to this, all of this was written in one paragraph. And as it's written in the new statute, which doesn't go into effect until January 1, I wrote it out 1, 2, or 3, so people know that they have 3 different options of cancellation.
So the rule needs to be changed because the statute changed.
Correct.
Does the statute not by itself take care of it, or do we have to have a rule to do it?
The rule would not be consistent with the statute, so.
Thank you.
Mr. Chairman.
And let me just ask one more question. The statute, what did it do to help consumer protection, for lack of a better term?
So it essentially has expanded the ways in which individuals can cancel a contract for a timeshare interval.
These ways to cancel are only related to timeshares.
Correct.
Okay. Jeff?
For number 3,
yes.
Can there be language added that says the mailbox that designated by the timeshare provider must be monitored and an auto reply must be generated to acknowledge receipt of the cancellation?
If you would like, I mean, this is just a suggestion of language, if that's language that the commission wants to be added.
I can see never got it, or we don't monitor that mailbox or all that other kind of stuff, and I kind of want to put those guardrails up for the consumer.
So we don't have any red.
But I do believe that my understanding is upon sending this notice, as it's being date stamped, it is considered to be received.
So they just have to prove they sent it.
Yes, so they would just need to prove that they sent it.
So the consumer just needs.
Yes. So, and I put insert address here. So in the particular contract from the timeshare interval, they would be the individuals that would fill in the address for that would need to be provided in number 2, and the email address in number 3. So
this is pretty straightforward.
Yes.
What do you need from us today?
So for today, I would just need a vote to approve the language in as amended, as drafted right now, so it can move through the process.
Second.
Motion by DJ Ferris, second by Ms. Torbett. The motion reflects the comments just made by our legal. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously.
Good job with that, Anna.
Thank you.
That was one of the simpler tasks she's had today, I suspect.
Anna.
All right, we ready to go to the other rule change?
Okay, the other rule change is related to content. So I took some creative licenses here. So I did essentially, I amended one rule and created a second. So based upon the new guidelines that we had. So for the first rule, we'll be amending is the one that originally stated correspondence courses. I have removed that talks about the term distance education and the information for computer-based DISC online materials. So it's just going to cover, that rule is just going to be for printed materials. nothing in the printed materials section has changed for that.
So this is more just a renumbering and a reorganizing?
Yes, so I just removed there because I'm going to put that in the new section that we're adding. And so the new section will be this new rule that is going to be labeled distance education. And so for distance education, it's been broken up into essentially 3 different sections. The first part is going to be definitions. Definition is going to be for definition as written in the statute that has been amended. The same goes for the definition for synchronous and asynchronous courses. Section relates to certification. That also is taken directly from the statute as well. The third section relates to synchronous course guidelines. Synchronous course guidelines, those are parts A, B, C, D, and E. A mentions the student and instructor course requirements, which would state that the computer, audio, video, you need a stable internet connection for class, and that the students are responsible for their own performance of their own technology. Students are required to attend 100% of the course for continuing education. B are requirements prior to course start time, which would be students must log in and check in for the class a minimum of 20 minutes prior to the noticed class start time. 2 is the proctors and instructors must verify the identification of students with the state or federal issued method of photo identification prior to the notice start time. And then C has the requirements during course. So staying visible on camera, your camera remaining stable and unmoved during the course. Number 3, not participating in non-course related computer-based or non-computer-based work. Not leaving the camera area during course. Prohibited from sharing a room unless you received prior permission. D, and then D talks about course conclusion requirements, which states that providers must maintain retain the recording. And then E is the language that I essentially added if there were changes that we needed to make down the road, so we wouldn't have to make changes to the rules so often. So it says the commission may add, amend, or delete any of the above mentioned guidelines by means of reasonable written notice to the course provider and instructor. Number 4 states that the commission will review the courses on the case-by-case basis. 5 mentions any course over 8 hours requiring a final examination. 6 talks about approval of distance or correspondence education is withdrawn if certifying body is discontinued for any reason. And then number 7 talks about a course on basic principles of real estate, including 1 student interaction for every 5 hours of credit. So this was based upon the feedback, the information that we had from the guidelines that we had thus far. So.
Okay, so just procedurally, today, you would like for us to vote on this, at which point it becomes, is it a preliminary vote? Then we let public comment on it, or how does this work at this point?
Right, so just like the other one, it would be approving this language as is, which means it would go through for both of the rules, just for everyone's information, would go through the internal approval, go to the governor's office for pre-review, and then it would be set for a rulemaking hearing. And then at the rulemaking hearing, that would be the time that we would have any public comments with individuals that have suggestions for changes to the rules, any comments in support or comments in the opposite of support, because we're framing everything in a positive way today.
Thank you.
And any other concerns or issues that we want to address at that time.
So, based on what you just said, the chair would love to entertain a motion to accept it.
Can I ask one question, though?
Can I get a motion?
So moved.
Okay, a motion by Ms. Frank, second by Ms. Torbett. Ms. Frank, you have the floor.
I'm wondering about proctoring.
Yes.
So this doesn't say anything about proctoring, and I think in my mind, where the at a certain number of students, does it require a proctor? If you've got 15, 20 students, probably just the person doing it is fine with doing it. If you get 100, I don't know how an instructor can instruct and then be watching, does everybody have their camera on? So that would be the only thing that I would see that I would like added, if there was some way of adding some language about proctoring.
Kind of like a ratio proctor per.
Yeah, one per, I don't know, one proctor per 50, or hunt. Well, if they're only watching the cameras and who's on there, not the instructor.
Does the commission have a preference on whether these courses would be sent to Ross in advance of the course being offered? Like
I
link.
think we still want everything to go to Ross, don't we?
I'm talking. Obviously, they'd be the courses we approve by the commission go to Ross, but the actual link to the course for a potential random audit.
Yes. Yes, that's great too.
Yeah, you don't have much to do anyhow, Ross, and so go drop in on a few courses.
Alabama has 4 people in the education department.
Wow. So back to the proctoring question. Ross, do you have any input on that? How many people can an instructor make sure is present while he or she is teaching?
In reviewing all this, Mr. Chairman, members of the commission, I feel like that 50 may be a bit tad much. I think maybe a classroom of 30 at least would require a proctor to keep up with their attendance and be sure that they're participating and whatnot, because you've got to monitor all those folks. And so I would want to set it at least a classroom of 30.
And then and at that point you need a proctor. And then at what is there a time that you would need 2 proctors if you got over 100?
I think
there's not a lot of classes over
100 though. At least the 30. If you go up and say 50 to 75, then you may need the 2. I've never seen a situation, it hasn't been reviewed by me, where you had 2 proctors. It was only the 1.
Well, why don't we go with 1 and see how that works?
So this is instructor plus a proctor for a class of 30.
Yeah, you got the instructor, but you got to have the proctor to
31
monitor.
or more.
31 or more students, or once they get to 30?
I would say 30 or more.
So you'd like to have that built into this rule?
Yeah, and Anna, if we could just put that in here. I don't want to hold up the vote for today. I'd like for us to go ahead and vote on this.
I can add the language. So
Okay.
if the class has 30 or more, it needs a proctor.
Yes.
So do we want to do a proctor per 30 people, or just
half the number of people?
If I was doing nothing but proctoring, I could scroll, page. I think if we left it at 1 person, let's see how it goes. If we see that we need to, she has the language in here that we can add more. We could add if 1 proctor is not enough.
do you think, Anna? 1 per 30 or?
I mean, I don't have like specific points of view about like the proctor per person, but like if I feel like there might want to be a cap because like I don't know how many people are in these classes.
This is something, Ross, that you could ask on the listserv from Morello to see what others are doing. Because it's a conversation that everybody's having right now about proctors.
Okay, I was just like wondering. So if there are 29 people, no proctor, but 200 a proctor.
For every 30 people, a proctor? You want that? I just think as a proctor, I could look at more than 30 people at a time. That's all you're doing is going through them.
Yeah, I would just like if we're gonna do a number, I would like to know. Like I don't want to cap schools.
I'm just thinking the lowest bar we can set is 1 proctor. Let's see how that goes. Do we see if we're going to have 100? Usually there's not 100 people in the class, not in my experience. But if it happens, then you have language in here that we can change that. And we can decide that 1 is not enough.
I also wonder if putting the responsibility on the provider to ensure that all of their students in their courses are meeting these requirements that we've outlined.
Yes.
And if they're not meeting those requirements, then it's up to the provider to determine whether the student should get credit for the course.
Yes.
And so I think in some ways the business can decide if 1 proctor, if they can manage all of the requirements required in the rule.
Good. I think that's a great point. I was recalling GNR, and I did an online course, and there was at least 1 proctor, and there was about 40 or 50 of us there. So, put it on the provider. Great.
So is there a motion? Or I need to make
we have a motion.
Okay.
I had to talk over you to get that motion.
I'm sorry, John.
But I want to make sure that we've given Anna the direction she needs before we vote. So, I think we're ready to vote, Anna. But do you have what you need from us before we vote? We're going to approve what you've presented with throwing a proctor in and making sure that the sponsor of the course is responsible for making sure those students are where they're supposed to be. With that information, is that enough for us to go ahead and vote? Thank you. All right. You've heard the motion. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no, and that motion passes unanimously. Thanks for your work on that. Ross?
One other thing to bring up, I think it's a good segue, but we're requiring the synchronous and or the asynchronous at least to keep recordings of this. So I've been asking about several providers about what's the retention time. Is it 2 years? Because I guess a lot of this goes up out or whatnot, but
Their renewal is every 2 years, isn't it? Is that 2 years or 3 years?
but it affects the licensees, and theirs is staggered. So
what do you tell them?
I tell them now the law doesn't really restrict the amount of time or give us a retention time. The commission will have to decide.
You're required to be retained, but you don't tell them how long they have to keep.
That's right. I can't.
So you'd like for us to give you a date certain to tell them.
That would be good.
Any thoughts, Commission? Steve?
1 year.
You want to make that a motion?
I make a motion for 1 year.
Is there a second? I get that. So that motion is on the floor. Now we can discuss it. Caitlin?
I am concerned about 1 year only because the license renewal cycle is 2 years. And then we also have our 120-hour requirement that is a 3-year. We have not really had this as an issue in the past. But if it did come up, I think we've had it come up once where a licensee had claimed to have taken courses, and we did have to go back to the provider to determine if there was an error in their submission. So it potentially could be worth making it a 4-year.
I'm not going to make that motion.
It's in the cloud.
It's still have to. You still. It's.
I want to play poker with Steve.
Oh, there is it's forever.
Less is more.
Caitlin's point right now is it's forever.
Right.
So your motion, which is properly on the floor, is to limit that keeping of the records for 1 year.
I was thinking the submittals happen within a year, right? Or no?
They're supposed to happen within 10 days is what the rule currently says. Is like if you take a course, it is required to be submitted to us within 10 days.
I was just trying to think of a time where there would be no debate whether they got credit or not, whatever that time is. I was thinking it was a year, but maybe it's 2.
Now listen, here's a good point. Rarely, but occasionally we have a licensee say, I took that course, and the provider of that course didn't either document it or he didn't take it, one or the other. So if it's in the cloud somewhere and they can pull that down and show that recording with that face, I mean, we can document that he or she took the course. That's the kind of issue that staff has to deal with.
Chairman,
yes, Joe.
I'd like to make a substitute motion.
Okay.
That they are required to keep that for 4 years.
I just second motion by Mr. Bagley, second by Ms. Franks, that the retention be capped at a minimum retention be 4 years. Is there discussion on that?
Yes, sir.
Yes, please.
So when a student completes the course, they get a course completion certificate. Isn't that correct?
That is correct.
And are those course completion certificates included in their retention of records?
The licensee?
Yeah.
Well, right now the rule requires that the provider submit it. And I think part of that is because we all have this is just what I gathered, that, and we have had this happen also only one time to my knowledge, where it was alleged that a licensee potentially altered their course certificate. And so we have required that responsibility to be on the provider to submit it to alleviate those kind of issues.
Okay. Thank you, Mr. Chairman.
All right, any other discussion? Let's vote. The motion is to set a minimum 4-year retention for, is it synchronous or asynchronous courses, Ross? Okay, I'm okay with it. I just
You said for both.
For both, yeah.
Both asynchronous.
I'd heard somebody call for the question, so let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no, and that motion passes unanimously.
Got it. You heard me.
I thought it was you, Stacy. All right, we have one other item. There's and we don't generally get into business practices, so let me preface any discussion on this by saying we typically, if somebody wants to work their business a certain way or another, but it's been brought to my attention and perhaps to others that there's a business practice out there that looks something like this. A company goes to a property owner and says, I'll give you X number of dollars.
$600.
It doesn't matter. It could be
low amount.
We're talking conceptual right now. I'll give you X number of dollars, and in return, all you have to do is commit that if you or your heirs sell the property in the next X number of years, let's say 30 or 40 years, you'll have to use us. So,
and if you don't,
at least what was brought to my attention is that company will file a lien on the property, and you can't get it closed until you pay the agreed upon amount.
Liquidated damages in the amount of 3% or $197,000, whichever is greater.
So, really, I would hope that legal
New concept.
I would hope to see if legal has an opinion on this. Is that within our purview, or is this like a consumer affairs issue or an attorney general affairs, or is it just a business practice that people can go with? Have you all talked through that?
It's new nationwide.
Well, we did have an overall discussion, and the information contained was concerning. At this time, we do not have any complaints that are exactly on par to the situation. There's information that we definitely want to take further look at regarding the information contained in these documents. Would also like to further reiterate that, unfortunately, as it was stated before, it is a right to contract poorly. So it is unfortunate that the business, we're in the gray area of getting into business practices of other individuals, and we don't want to get into the territory of interfering with business relations or business contracts in that area. But we also do want to make sure that we are protecting consumers and making sure that they do get the most up-to-date information and are educated with information if this situation was to come to them. So we're still looking into it, and if the situation is to come our way, we'll definitely look into it. It still just seems very broad when we were looking at it. And I think ultimately we were, of course, when we look at things, we go into the future and look at risk and mitigate those types of things. They're just like general concerns of how broad the complaints are, the documents are in general. But overall, it does look to be concerning. But we did have an opportunity to look at it.
I think it's something this commission may or may not need to address, but it's emerging. Let's put it that way at this point.
Right. No, if a complaint was filed, of course we would look into it and do the best that we could with the tools that we can.
And I brought this to the attention. It was something that I received in a listserv from Arello. And really, it's new in all the states where this is happening. So I just wanted, and I sent it to Caitlin and Anna, just so to make everybody aware that there are so many different changes in business styles now. And it is not our place to judge any of those styles, but just to let you be aware, if anybody says anything to you about, if you know anything about it, that it is something. But at this point, no need to do anything about it. But we can't be thinking in the future, what would we do about it if there was a problem?
We're a consumer protection agency,
right.
And there's a case can be made that consumers need to be protected. Mm-hmm. On the other hand, the case can be made that somebody else ought to be protecting them, not us. Mm-hmm. So we will see how that goes. All right, Anna, thank you. Anything else for us? Dennis? Caitlin?
Nothing else. I do want to note that everybody keeps talking about this being your last meeting, but as we all know, you serve at the pleasure of the governor. So I hope that we see you next month. Yep. And if not, then I just want, on behalf of the commission staff, to say thank you for being such a wonderful chair.
So, Chairman, you only get one party, though.
I know, one party. We can do it.
We can have a party every month as long as the governor lets him. We'll invite the governor to come.
So, whoever is the next chair will get to have a special relationship with Caitlin, because there are discussions we have that are appropriate to the business of the Real Estate Commission. And sometimes in my role to try to lead, guide, and direct what our meeting looks like, it's because I've had background and discussions with Caitlin, who I brag on all the time, and I'll do it one more time. My job and our job is so much easier because it's pretty seamless when you get right down to it. You take. Assuming I'm not here next month, here's my main wish for you people: that these dang plexiglass things come down.
Yes.
That's what I want. That's what I want. Thank you. One's down, several to go. All right. Anything, Joe, before we go? Jeff?
Yeah. I hope this isn't your last meeting.
Yeah, okay, thanks. By the way, we get paid up to $50 a day to be here, so I've got a financial reason to want to come back for sure.
All the way from Knoxville. He pays more in gas than that.
Jeff, anything? You be safe going home, okay?
That's up to Steve.
Oh, yeah, Steve, be safe. DJ? Thank you, guys. John's been, of all the people I've had a pleasure to get to know, and there have been a lot of them, and when the commissioner talked this morning about the relationship between us, it is a special relationship. Very few commissions meet monthly. We're one of the few that does. Many commissions members make their own hotel reservations. This commission has been spoiled because staff has taken upon itself to try to help out with that, and they do a great job. But we don't always agree, but we don't ever get mad at each other, I hope. I don't think I've ever seen that. There's no pettiness. These are commissioners who are doing their dangdest to try to represent the consumers in the state of Tennessee. And it's a paradigm shift for real estate agents who've typically looked out for their industry, and here we're trying to look out for the consumer and not our industry. These guys do a great job. Staff does a great job. And in case it is my last meeting, I encourage you to lean on that staff as much as you can, but make your own dang decision. All right? Anybody? Joan, John?
I just want to say one thing.
Okay.
John can never take a compliment without complimenting everyone else in the room. That's just John. Every time a compliment's made, that's what he does. He has been a great leader. A great friend to all of us. He's made it fun for us, but he's serious about it, and you just have no idea. I'm in my 9th year, so I have one more year, and then I'll be gone too. But I've sat here with him the longest, I guess, and he doesn't miss meetings. Last year he had 2 knee replacements and 2 hip replacements and did not miss a meeting. He does not miss a meeting. He drives from Knoxville every time. I live in Franklin. It's not hard for me to get here. But 2/3 of the people here are not from Middle Tennessee. And they're driving every single month to these meetings. And sometimes they drive from Johnson City to Memphis for our meetings, and then vice versa. So John has always been the one that was our team leader and made us want to be there. And actually, it's serious business, but we have fun when John's with us. I don't know what we're going to do when he's gone, so you may have to just phone it in or something. He loves Zoom and WebEx so much. But we are really, really thankful for his time here with us.
Martha, I'd like to compliment you, Marcia, compliment you on your remarks.
See?
All right, ladies and gentlemen, if you want credit, you have to sign out.
Don't forget your banner.
Thank you for coming, and I hope you're all going to be home safely shortly. Yes, ma'am.
We appreciate all. Okay. So do we want to stand in front of this?